this morning, and we are going to start our day in a good way with Elders Delia and Latash Nahaney. Please come when you're ready.
Asiyam Tanoyap Tanoan Siam and Siaya Sayoyakwa Tlakchit Nomin on hot and swallowing. Nesta uns Latash Kushamin Tanalachan Osahano Kameo Skohomishoth. Greetings to all of you. Very happy in my heart to be with all of you today. Just want to welcome you to the gathering today. It's issues that are very close to my heart. I have a lot of concerns and love for my community, and it's been a difficult road for a long time. But things are getting much better, and it takes a community to make things happen. And thank you all for your concerns and for being here today.
OCM, welcome. We were talking earlier this morning, and we're talking about our ways of healing as Aboriginal people. And I remembered a time when I was a social worker, and I had to meet with this young woman. And so I went over to her place, and I just sat down and, talked to her like an auntie. And so, how's it going? How are the family? How's the kids? And she showed me a bunch of the, pictures of her kids, and we laughed all about all the funny things they did. And, and I said, see, I said, so why are we meeting? Do you want to maybe tell me what you think? And he says, yeah, well, I have a drinking problem, and and ministry has been called, and I said, I didn't know that. I said, I haven't really noticed that in the community, and she said, yeah, well, I keep it much under control, but it is affecting the children. And I'm like, oh, okay. So what can we do about this? And she goes, well, I've been thinking about joining the canoe club. I've been thinking about joining the canoe club because there's the canoe family. They hold each other up. They're there for each other, and I'll be accountable in the community by my aunties and my uncles, and it's a very strict policy of no drinking while you're on this canoe club. And I thought, that's brilliant. And she thought of this all on her own. And I said, wow, okay. Why don't we write this plan together, and then you sign off on it, and I'll bring it to my supervisor. And so we wrote the plan together, brought it to the supervisor. Supervisor thought it was fantastic, but she said, "But Delia, this is in protection, so this goes to ministry, because we weren't leveled up to be protection." And so I said, okay. So we went to. So I brought this young lady over to the ministry, and they said no. And no, and I just couldn't for the life of me figure out why they said no, because she brought up this plan on her own, and she was well invested in it, and they handed me this thick catalog, and they plopped it down. They said, look through there and pick one out. and I was ready to cry, and I felt really bad because I didn't know how to advocate for her. That she, like her ideas were kind of, said they were wrong or they were bad. I'm like, or they weren't validated. And I felt unvalidated as an Aboriginal person, as a Squamish Nation person. And I was even upset on behalf of this canoe club, but we said, well, I think if you choose somebody in the canoe club who can help you with one of these programs, maybe they can come with you and and do it that way. So she thought about it, but you could see that she was really defeated. She was struggling already with something that she didn't understand. And then when her brilliant plan was food. I don't have a better word for it, but it was. So I just want to advocate for a lot of people. Let them find their plans. Let them. Let the client lead you through the plan, because that is going to be their best bet. That is going to be their best bet at the end of the day. She did eventually join the canoe club, and she did quit drinking. She's, amazing. She's, I see her in the community all the time, smiling and, very strong woman, and and I'm very proud of her. I think, we have to have the strength in our own laws as Aboriginal people. We have to know how to advocate for ourselves and say, hey, this is the route that we need to go.
Okay. So the Canoe Journey Club is one example in our community. For the Squamish Nation, we have the winter ceremonial dances, and these dances they're not public events. They're more of a really profoundly spiritual gathering of our people on weekends. And these dances, they take place on weekends throughout Coast Salish territory, on Vancouver Island, northern Washington State. So a lot of time, excuse me, a lot of time is invested in being a participant in these spiritual events, and there's a very strict code of conduct that goes along with being a member of this particular cultural activity. Powwows are the same. They're very strict code of conduct, and they require that people do not drink, for example, or do drugs. And but they're not very well supported by mainstream, and yet they are within the community-driven to help our people. It's not to say that we want to be different or we want to be apart, but they actually help our lifestyles so that we can participate in the modern economy and be a contributing member of our community. And yet they don't receive much support when it comes to meetings like this, for example, are not mentioned too much. But I would encourage the justice system to look into how it can support our community activities that are very healthy. And a lot of communities all over the world have similar activities that help support a healthy lifestyle. Like, for example, sports or the Olympic Games, very high levels of competitions. And we look up to these people as heroes. It's really remarkable what the human body can achieve when given the chance to do so. But again, thank you for having us here today, and have a good day.
Morning, everybody. So we're going to thank our elders first. Thank you for those words and for opening us in a good way. We're going to start today by welcoming back Jonathan Rudin, who I'm sure left an impression yesterday as he was referenced throughout everybody else's presentations. He's going to continue today speaking about Gladue in bail, which it was touched on yesterday, and I know it's something that's it's an interesting topic, and it's a lot of intersectionality that comes between how to use those Gladue factors at that time and the balance between actually being able to talk about that when you still have a client who's maintaining their innocence at the bail stage. So I'll just welcome up Jonathan Rudin.
Thanks, Amandeep, and thanks to the elders for your words. They're very important. I'm going to try and remember to touch on them during my remarks because I think they're really crucial. Before I get into the bail thing, I just wanted to pick up a couple things that were discussed yesterday afternoon from Justices Wolf and Marchand. First, I want to give you the cites of two cases that Justice Marchand mentioned about joint positions. He talked about TLC, which, if you're interested, is 2019. I'm telling you this because Amandeep, I'm sure, is going to write it into the chat, so you don't have to do it, but I want to make sure you ready? Okay, so TLC 2019 BCPC 314, and LaForge is 2020 BCSC 1269. And I just want to talk, again, before I get into bail, just for a minute about joint positions. Because it's something I've been thinking about a lot recently. A few things about joint positions that I think lawyers don't always understand. Anthony Cook, of course, is the leading case. And people sort of think when you say joint position, Anthony Cook descends down and confers upon your joint position sort of kryptonite, so judges cannot interfere with it. So just to keep in mind a couple things. One, Anthony Cook distinguishes between jumping a joint position and undercutting a joint position. LaForge and TLC are judges undercutting positions, and that is different than jumping. There are less concerns. Supreme Court speaks about that specifically in Anthony Cook. But the other thing I want to say about joint positions is there is confusion about what a joint position is. And I'm going to be involved in a case in September at the Ontario Court of Appeal where we're going to be raising this issue. I don't know whether the Court of Appeal will take it up, but we're going to be raising this issue. If you read Anthony Cook, the idea of a joint position is something where there is a quid pro quo, where the Crown gives something up in order to get a conviction and a plea. Not everything is really a quid pro quo, and I would suggest that a lot of things that get presented to the court as joint positions aren't really joint positions, because what the Crown is doing is taking off a couple charges that never should have been laid in the first place in response to a plea. So this is going to relate to bail very specifically, but someone who's in custody, who's facing 2 substantive charges and 5 fail to appear, is not an unusual situation where I am. And the Crown says, okay, I'll take a plea and I'll take 2 fail to appears off. That's not a joint position. Like, what the Crown has given nothing up. They were going to get a conviction anyway. There's no difficulty. And I think we need to be careful about this. And I certainly encourage judges, whenever I can, to challenge some of these joint positions. I think things that pass as joint positions that are like 30 days, 60 days, those are, and I'm struggling here to find the polite word. So my feeling is, if you're going forward with a 30 or 60-day position, what that is a testament to the lack of imagination on the part of counsel. 30 to 60-day sentences are stupid, they are pointless, but they are also damaging. And this is something I think people don't always keep in mind. 30-day sentences mean people lose their housing, they can lose access to social benefits, women in particular can lose their children. Like, these are really significant things. And I don't consider it advocacy I mean, what I think probably doesn't matter, except I have the mic. So I don't consider it advocacy to go for the Crown to say 30 and you say 15. Like, that's not advocacy. If the Crown wants 30 days, just come up with something sensible that's not stupid, and just go with that. I really think the average sentence in Canada, is 30 days. That's the average custodial sentence. It's slightly higher for Indigenous people. If we want to deal with overrepresentation, mass incarceration, we stop sending Indigenous people to jail for stupid short periods of time. And we get out of this, oh, it's all okay, here we're working things through really quickly. Like, let's not let expedience be the driver. And I know it's easy to say, but joint positions I think are problematic, can be problematic, and that's why we're going to do our bit to try and demystify joint positions, and I hope the courts will start to sort of look at joint positions more critically. Anyway, that's my joint position rant, and now I'm going to go into bail. And the reason we have a whole discussion, and the whole reason that we're focusing specifically on bail is because really the most important decision that a judicial officer makes in any case is whether the individual is released or not. That is the biggest issue. Not whether they're guilty or not guilty. Now, obviously, that's important. But we know from all sorts of studies that if you are denied bail, the odds are you're going to plead guilty because you've been denied bail, or you're going to be found guilty because you're not going to have as much time to work on your defense. You're not going to be able to spend as much time with your lawyer. Sentencing outcomes for people who are denied bail are almost always much worse. When I read decisions, Gladue decisions, and I read every reported decision on Gladue I read because I have a problem. Hi, my name's Jonathan, I have a problem. But when you read these decisions where you get very creative sentences, where people now that they have access to conditional sentences get a conditional sentence, and where you wouldn't expect that, inevitably, in all these cases, the individual has been on bail and has been able to do things while they're on bail to show the court that they are able to do the various things they're supposed to do. When someone is in custody, and you know this, you represent someone and you say, Your Honor, my client they're registered for this program and that program, they're really committed to change, etc. And the court, everyone's thinking, oh, yeah. I know he says that or she says that. I'm sure maybe even she means it, but she's in custody. Like, what is it? How do we know she's going to do this or he's going to do this? So getting the client out on bail, then connecting them with court workers and Gladue caseworkers and all these things are really important. But that's when you get significant results. So bail is the crucial decision, I think. So with that preamble, so in terms of bail, prior to 2019, there was a lot of confusion about whether Gladue applied to bail or not. I don't know why there was that confusion, because in Gladue itself and the Gladue decision itself, the Supreme Court speaks about one of the causes of overrepresentation as being sort of a propensity for judges to refuse bail to Indigenous people. And there was controversy at various courts around whether Gladue applied to bail, but in 2019 it was all put to rest with Bill C-75, which says in 493.2, in making a decision under this part, a justice or judge shall give particular attention to the circumstances of Aboriginal accused. So that answers the question, and then raises a host of other questions. Because what does it mean, consider the circumstances of an Aboriginal accused at bail? Because this is very similar language to the language used in 718.2e, the circumstances of Aboriginal people at sentencing. And one of the challenges, and we see this a lot in the case law, is that everyone in the room, when they start thinking about Gladue, already start thinking about sentencing. And everything they do is sort of oriented around sentencing because that's kind of what we know and associate with Gladue. And that's not helpful at the bail stage. That takes you down the wrong path. And I think it's really important to stress and think about what it means to apply Gladue at bail. It is not to start the sentence. It's not to start the sentence early. So here's, I did massive amount of research. February 2023, non-Indigenous people in BC are more likely to receive bail, than Indigenous people. There's an extra non. I did a lot of research, but not a lot of checking. So this is a reality that Indigenous people in this province, even a couple years ago, have more difficulty getting bail. And that's important to know because that starts to speak to why is it that Indigenous people have a harder time getting bail? And how does that relate to Gladue? Because there are links. There are links, and it's a case of trying to make those links. So as I said, bail isn't sentencing, right? You are presumed innocent. You want to get people away from this desire to treat. I mean, would it be good if the person stopped drinking? Oh, yeah. Would it be good if the person enrolled in some education programs? Oh, yeah. Those would all be good things. But that's not what bail is about. Bail is about responding to statutory considerations set out in the criminal code. The Supreme Court in Zora makes it clear, and I think this is always the question you should ask yourself when you're considering if you're a Crown proposing a bail condition, if you're defense counsel, if you're advancing a bail condition. Do you want your client to go to jail if they don't do this? Because that's what a bail condition is. If we think therapeutically, we forget that. We think, oh, great, it'd be great, do this. It'll be so much better for your life. Yeah, it will be. But if you don't do it, it's a condition of the court. The consequence is you could go to jail. Is this something that is so significant the person should go to jail? And this is the problem with bail conditions generally. And again, I really, Supreme Court has had a whole bunch of decisions on this. Antic, Zora is a really good decision. Judges and everyone just loves piling conditions on people at bail. We get all sorts of conditions that are not necessary. They don't address the primary, secondary, tertiary grounds. And we're engaging essentially in social work. And let me just say, you're all wonderful people. Other than Delia, I don't think any of you are social workers. So don't muck around where you're not competent, okay? And you're not competent in social work. So don't start to do that. Leave that to the professionals. You have a good set of skills, use those skills. But don't try and move into social work, because social work is not meant to be coercive. This bail is coercive, and let's always keep in mind, bail is a coercive process. You do this or else. So always keep that top of mind. And it can be hard. I know. I mean, I am mindful of the realities of bail court. I'm mindful of how difficult it is. I'm mindful that contested bail hearings are often a challenge just because you don't have time for them. There's a lot of pressure to try and come up with joint bail positions. Crowns can be very unreasonable, but we have to resist these things. I mean, Zora talks about the ridiculous use of abstention clauses, which I think are now probably gone. I didn't do a Slido thing. So are people still finding their clients are being, raise your hand or no? So you're still getting it? Oh,
certain jurisdictions.
Okay, so I really do recommend, don't cite me for this because no one's going to care, but go to Zora and start, quote this stuff back to courts. Like, just say, if you want to do this, here's what it says in Zora about this. The courts are really clear. Giving an abstention clause to someone who is an alcoholic is both, it could be, in fact, medically dangerous. I mean, we have to keep that in mind. People, if you are severely alcoholic and you just stop like that, you can die. So you're also not doctors, neither is the judge or JP. But go to Zora and quote it back to the judge and just say, okay, this is what the Supreme Court says. You're telling me, we don't want to follow this. Because these are just setting people up to fail. And Zora makes it really clear. It is really sad. And the courts are now starting to realize it's really sad when you sort of hold up to someone, do you want to be released? Do you want to be released? Okay. Do you promise you won't? I mean, people will say anything because who the hell wants to be on remand? Right? It's not a nice place to be. Can you stop? Oh, yeah, sure, whatever. And that is contributing to the problem. So we want to try and avoid that first. And I'm sorry to hear, but I'm not surprised that some judges and justices of the peace still rely on abstention clauses. There may be very, very few relative specific cases where it may be necessary, but it is generally not necessary. And we really want to avoid that because you're not only setting the client up to fail, but you're also setting them up to never be released on bail again if they're arrested because they will have a series of fail to appears. The other thing about Gladue at bail is you don't need the person's whole history. You don't need to know if they went to residential school, if their parents went to residential school. That's not what bail is about. It's not sentencing. You need to know why do we need a Gladue report? Because it speaks to what? It speaks to their moral blameworthiness, and it speaks perhaps to what some sentencing options would be. You are innocent. Someone is innocent at the bail stage. You don't need to worry about their moral blameworthiness. That's not a factor at bail. I may have this point later on in my slides, but I'll make it now and then I'll make it again. A colleague of mine described bail hearings where Indigenous people are sometimes testifying at their bail hearing or their parents are testifying at the bail hearing and they're going through their whole personal history. She describes this as settler voyeurism. Like, people don't need to expose their pain and their trauma and all those things in an incredibly difficult place for no purpose. And so I'm emphasizing this because it's really freaking important. We need to keep focused on what the purpose of this process is, who has the onus, and what are we doing. And so the reason that it's not about generally the personal history, and I will explain there are some points where there may be relevant. But the issue really, when we talk about Gladue applying at bail, is what are the systemic barriers that make it harder for Indigenous people to get bail. That's how Gladue applies at sentencing. We're looking at the systemic issues, the personal sometimes, but also systemic issues. So what are the systemic issues that make it harder for Indigenous people to get bail? And Justice Wolf referred to some of them yesterday. So we have, and again, there's language in Gladue and Ipili that speaks specifically to this, and in Zora. So impact of sureties. This demand that people have sureties. Well, that makes sense if you maybe have sureties, but if you're homeless, what are the odds you're going to have a surety? They're not going to be, they're not great. If you don't have housing, what are the odds that, you're going to, if there's a requirement for housing? Again, why? What's the point? Like, why does housing matter? I mean, if we take a step back, most of the bail conditions are designed to reflect sort of what middle-class people are. Oh, look, you have a job. Oh, look, you have a house. What does that mean? It means that you're probably not going to want to risk it all by screwing up, right? That's what it means. But those are not the primary, secondary, and tertiary grounds. Okay? Primary ground, are you going to show up? Now, housing doesn't guarantee you're going to show up. Depends where you live. If you live in a small community, you'll find people. Like, you have a housing, you don't have housing, you're going to find them because it's a small place. Even in Toronto, we have homeless clients. Yeah, they're homeless. It doesn't mean, you're going to find them sooner or later. It's not a big deal. It's not hard. So we need to drill down, and this is the part of when we talk about systemic discrimination. Systemic discrimination is treating everybody the same when their circumstances are different. Why is it that Indigenous people are disproportionately homeless? Why is it that they don't have people who have sureties? Why? Well, because it's because of the impacts of colonialism. So we can't pretend that doesn't exist, or we can't acknowledge its existence in theory and then say, oh, yes, but unfortunately no one gets bail because you don't have a place to live, you don't have a surety. So we need to drill down, and that's when we talk about Gladue applying at bail, is identifying those systemic issues and drilling down to them. This is what the court talks about in Zora. What is a reasonable condition? And the other thing that then becomes really important is because one of the things that, the Crown's always rely on, and again, going back to what I said yesterday, because I'm sure you remembered all of it, what you see is all there is. What does the Crown have? The Crown has the person's priors. Like, that's what they have. And in the bail context, they have the priors, and they just look. How many fail to appear and fail to comply are there? Like, you can't release him. Look, he's got 14 fail to appear. 42 fail to comply, whatever. I mean, you can't possibly release them because they have, and then often they say you just can't possibly release them. They don't finish the sentence. But what is, if you make people finish the sentence, what is it? Well, you can't release them because from this fail to appear or fail to comply, we are now going to draw an assumption about this individual that we don't know anything about. And that is, if they have failed to appear or failed to comply, they don't care. They have no respect for the system. They don't care about the system. And sometimes Crowns will say that aloud, and sometimes they won't. They'll just say, look at all the failed to appear, failed to comply, really. And I'm exaggerating. I'm sorry to Crowns. I'm just exaggerating. But, I go after defense counsel, too. And so we have this disproportionate reliance on particularly those sorts of priors. And we need to think about whether they are significant or how significant they are, or frankly, how insignificant they are. So we go back to something I talked about yesterday, false guilty pleas. I mean, think about how the system runs. So I'll just start with this quote from CK, from the Ontario Court of Appeal. Indigenous persons tend to plead guilty at materially higher rates than non-Indigenous persons. The most relevant explanation was offered by the Honourable Frank Yakabuchi, who explained that many Indigenous people plead guilty because they believe they will not receive a fair trial owing to racist attitudes prevalent in the justice system. And I also accept this proposition, which is a logical outcome of the despair that Indigenous persons no doubt face when caught up in the criminal justice system. And we also have this this revolving door, why bail is so important, and you will all have experienced this. Your client is arrested, they're denied bail. Their charges are relatively minor. How long does it take to get a trial in your jurisdictions, just roughly? 9 months for something small, okay? Well, this is not hard to figure out, is it? If you're denied bail, what is the only rational thing to do? The only rational thing to do is to plead. Like, why? I mean, again, this is from, you know, if you're not involved in the system, well, I never plead guilty to something I didn't do. Yeah, you ever been on remand? You and 17 of your closest friends in a few cells? Like, this is not nice. Remand is the worst. And it's the worst in theory because you're not guilty yet, so you don't entitle the program, blah. But it's also the worst because it also helps encourage people to plead. So people plead out because they're denied bail. This is the cycle. This is the cycle. You're charged, minor charges, way too long to wait. You plead. You take whatever deal's offered. I mean, this is not, again, I don't want to disparage Crowns, but it's not hard to get pleas when someone's looking at a whole bunch of time, dead time that they're never going to get back. Congratulations, you're acquitted. What about the 9 months I spent in custody? Yeah, well, you shouldn't have been arrested. Like, well, I don't know. Like, what are you supposed to say? So we have, and we know that Indigenous people are denied bail more often. So this is why all of this systemic stuff is so crucial, because otherwise we're just institutionalizing and building a juggernaut that will just continue to swallow up Indigenous people under the guise of saying, well, it's not that you're an Indigenous person. It's that you have all these fail to appears. It's not, you know, and so we're ignoring the systemic issues. Now, one of the things that happens when we talk about, when I certainly talked about this, it doesn't mean that every guilty plea is a false guilty plea, right? We can't assume that every guilty plea is a false guilty plea. But we can't assume similarly that it wasn't. And that's the crucial thing to keep in mind. Again, Ontario Court of Appeal recognizes false guilty pleas. You'll see if you look at CK, you'll see cites to, and I mentioned this yesterday, the heads of prosecution have reports out on false guilty pleas. Everybody knows false guilty pleas exist. And then we pretend that we don't know that stuff when it comes to bail hearings. Oh yeah, false guilty pleas, yeah, it's really tragic. Then it's bail hearings, suddenly every guilty plea is not a false guilty, is a valid guilty plea. And there's no question that you can't relitigate every guilty plea. You can't have a bail hearing where you relitigate every guilty plea. So how do we deal with this? And EB is, I think, a really good example. And it's cited in my book. But you actually have this chapter in your materials as a teaser. Because, wow, this is so exciting. I wonder what the rest of the book's like. Okay, publishers, I've now done my bit. All right. So EB, he has some serious charges. And he has 25 priors for breaches, 25 priors. And first thing the court says is, he's got 25 priors, but we don't know how reasonable any of those other bail conditions were. I remember working with, we had a client that we worked with who lived in a town outside of Toronto. And he got arrested all the time. And he was released on an abstention clause, and he was addicted. And he would literally get arrested every day or two and be charged with fail to comply. And he would then plead. So you looked at his record, and it was pages and pages and pages of fail to comply. But the condition was stupid to begin with. So we can't assume, again, we can't assume, we don't know, but we can't assume that the conditions the person was released on, particularly based on Zora, were reasonable conditions. Maybe they were there's a better word, there actually isn't a better word than stupid, but there is a better word to use in court than stupid in front of a justice of the peace who might have imposed those conditions. So think about that. But we can't assume, and in fact, it's probably fair to assume, that a number of those conditions were probably not reasonable to begin with. So once again, what does that mean? It means we can't draw the inference. What we're doing with all of these things is we're saying, because of X, I'm going to assume Y. I can't look in your heart. I don't know whether you're going to show up. So as a proxy, I'm going to look at, fail to appear, convict, fail to appear, fail to comply. So many of the conditions may be unreasonable. And then that leads to what Justice Schreck talks about in EB, that it leads to this revolving door, which is you don't get released, so then you plead guilty. Are you guilty of all these things? Who knows? But we have to, once you start acknowledging the reality, once you look behind the curtain, that's a Wizard of Oz reference, actually. Do people still get that? Okay, good. I wasn't sure whether, because we have this tendency, again, we sort of look behind the curtain, then close the curtain, then pretend we didn't look behind the curtain. Like, no, we know why people are pleading guilty. So let's not put this emphasis on the fail to comply charges as though they are significant. They may be, but they may not be. And that's all the justice of the peace or the judge needs to know. It's not, you don't have to relitigate each of them. It's just to say it is as likely that they were an unreasonable condition as they were a reasonable condition. And that just means you should put little weight on them. And you may call evidence. There may be evidence. You know, the person may have breach charges. One of the things that may be relevant about the person is maybe a number of the breach charges were abstention charges, and maybe they may have had an addiction which they've now dealt with. So it may be relevant to say that, you know, they had from the period, you know, the last, 4 years ago or 7 years ago to 4 years ago, they had a bunch of breach charges. They don't have any anymore. Why? Because they were drinking before and now they're not drinking. That may be relevant. But that's a narrow purpose. That's a narrow purpose. I want to see what the next slide says before I... Okay, so let me just talk about another... Get to Cadjo look in a minute. Another set of fail to attend. Fail to attend are often used as a reason to deny people bail. And we need to look at the systemic reasons behind that. And I think about jurisdictions certainly in Ontario. A lot of court jurisdictions are at some distance from where Indigenous people live. There's a place that now has a court on reserve, but it was Walpole Island, and Walpole Island's a long way from Sarnia, where the court is. It's like 30, 40-minute drive on the highway. A lot of people on Walpole didn't have cars. A lot of cars that people had were res cars. That will have meaning to some people. So you don't want them. You can't. You don't want. I mean, you really. They're not on the highway. They shouldn't be on the highway. People, and there's no public transit. Six Nations, one of the largest First Nations in Canada, right near Brantford. There's no bus service. Really expensive to take cabs. People sometimes have, maybe not as much now, but people would have 6, 7 appearances before their matter was resolved. That they missed court is not because they don't care. It's because they may have 40, 50, 60, 70, 80 bucks to show up for court for an appearance where they get to say, yeah, I don't have a lawyer yet. And then they want, like that's a systemic factor. And we need to look at those things. You need to look at where your client was living. How hard was it to get to the court from where they are. And it could have been hard, frankly, just because they're homeless and they're addicted. But those are things that, again, we need to bring to the court's attention, because because you're making assumptions about the individual that may be unfounded. If you practice outside of Vancouver, and the catchment area for your court includes a number of First Nations, find out how you get from the First Nation to town. Like, ask somebody, ask your client, ask the court workers, ask people, how do you actually get from here to there? Because you can be sure, almost sure, that the judge probably won't know. And the Crown probably won't know. And almost nobody will know. And because nobody knows, people make assumptions. So one of the things that's really important is for you to try and understand those things. And if you're a Crown, for you to understand those things. And now I'm going to go on to this rant that I have a series of them. I've now clicked, okay, rant, this rant. Okay, so here's the rant about knowing about the places, the people and the places that you serve. And again, I want to acknowledge, I know courts are really busy. And what happens in busy courts is that we reach out to the people who we know are in the court. Like, the resources are the people in the court. So again, I'll just think in Toronto, Salvation Army has an office. St. Leonard's has an office. E-Fry has an office. If those people are easy for me to reach, then I'll go there and talk to them. And they're going to be the people that I'm going to want to refer people to. But to get to Delia's point, if I don't know that there's a canoe club, I don't know what the canoe club is. If my client says, I want to go to the canoe club, I go, yeah, sure, you want to go to the canoe club, but I don't have time. I don't know what the canoe club is. I want to know, here's the list. Like, give me something that everybody in the room knows about so we can all talk the same language. And sure, maybe not be relevant to you, but you'll get out on bail, even though you may be breaching. So learn about the resources that are available in the community, both the community in the courthouse area, but also on the First Nations. Speak to the court workers. I mean, the reality is most Indigenous organizations outside of court workers, and BCFNJC, don't have presence in the court. So you're not going to know what they are. You don't know what they have. But it doesn't mean you can't learn. It doesn't mean you can't know. And again, find out how you get from point A to point B. Because if you don't find out, everyone in the room is going to assume, well, it's only, the res is only 40 kilometers away. How hard can it be? Maybe it isn't, but maybe it is. Like, it's amazing what we don't know about the people who make up a disproportionate number of people in court. It's amazing what we don't know. And it's amazing how we just fill in the gaps with assumptions and we never question them. And I think you'll see if you start to actually provide information, people go, oh, I really didn't know that. I don't know how many, I think it's incumbent on Crowns to visit all the communities in their jurisdiction. I think if you represent people from communities, you should actually go to those communities, visit, take a look, see what resources are there. Because then you can speak with some knowledge about what's going on. If you're in Vancouver, go to some of the Indigenous organizations, go to the Friendship Center. What do you actually offer? How do you access these programs? Like, try and figure those things out. Or if you don't want to go outside, then reach out to the organizations and set up a lunch and learn. So invite them to come to the court. It's so thrilling for people to go through court security too when they, but find out what's actually going on. Find out what resources are there, and then you're able to come up with realistic bail plans, realistic options that are actually meaningful. Because too often, again, go to Delia's point, too often what we're saying to someone is, you do this because it's convenient for us. not because it's going to be meaningful for you. And that's not going to result in a lot of positive responses. So I should point out that there are EB. One of the points in EB is that the analysis includes the secondary ground. In other words, is there a danger to the public? How do you assess that? And EB suggests, and it's cited in the chapter you have, and you can read it in the decision, that you can look at secondary ground, danger to the public, danger to a particular individual, through a Gladue lens. Kaduluk suggests that's wrong. There is a distinction, a dispute on this point. As I said, it's been followed in New Brunswick. Just recently, just like last week, the Alberta Court of Appeal in a decision called Rain references Kaduluk. I'm not quite sure where they came down on it. But I think EB is correct. And Gladue applies, the Gladue considerations apply to the primary, secondary, and even tertiary grounds. There is a tertiary ground case that's mentioned in the chapter that you have. It's hard to find. It's not that well reported. Where in the tertiary grounds, this discussion is, would releasing the person cause, shock to the community, even though they're not a danger, et cetera, et cetera. And they apply Gladue to the tertiary ground. A reasonable person knowing about the over-incarceration of Indigenous people, would they be outraged if the person was released? And if from a Gladue perspective, they wouldn't be, then the person should be released. So the Gladue analysis in 493.2 applies throughout the all the grounds. One of the points I think that EB makes that's important is that 493.2, like Gladue, is a substantive change to the criminal justice system. It's not procedural. It's not simply recording what we all knew. To the same extent that Gladue meant that everyone has to rethink the way we do sentencing, 493.2 requires us to rethink the way we do bail for Indigenous people. I think that's the correct analysis. I can't give you some BC Superior or Supreme Court decisions on that, but you may have them. I haven't seen them yet. So now we get to Gladue reports. So they're not, my position is they're not necessary at bail for a lot of obvious reasons. First, Amandeep would be overwhelmed, and we don't really, look at it. You want to make her life even harder? No, you don't. It's a wonderful, caring person. But also, you're going to be waiting 4, 5, 6, let's pretend, 4, 5, 6 weeks or more. But even though did your client want to wait 6 weeks for a report, for a bail hearing? No. Why and why? For what? To what end? The person's innocent. They're not going to be able to talk about the charges, right? Because they're innocent. So you're not going to talk about the charges. So what is it that you're going to get out of a Gladue report? And again, generally, personal and family background stuff is not relevant or necessary at bail. Again, I'm going to give you there's some cases, give you some examples of where that has come up and where it may be useful. But it's generally not necessary. So why put people through that? Why, can your mom or dad come to a bail hearing to testify about their life? Why do you want to do that? What? Always ask yourself, what's the relevance? And so you don't need a Gladue report. It doesn't mean you don't need information, but again, as we talked about yesterday, there are many ways of getting information. You can get the information yourself, but you're not going to get it through a Gladue report. So again, your focus needs to be on the primary, secondary, and tertiary ground. It's actually the Crown's focus because it's the Crown's onus, unless it's a 524 case, but you know, that's, and even in a 524 case, it's still up, eventually the Crown's got to show why it's still, the principle is the person should be released. And don't forget, the Supreme Court keeps saying in Antic and all these cases, the presumption is you are to be released. I know that's not how bail courts usually function. They don't function on it, but the basis is you're supposed to be released. And then if you can't be released, what is the least restrictive release that's necessary? That's how the bail system is supposed to work. Supreme Court has sort of made it a project of theirs over a number of years with Antic and Zora and Myers in a number of cases to try and reform bail. And to some extent they've worked, and to some extent they haven't, because the bail system is used to running the way it runs. But it's always good to remind yourself and remind the court of the way the bail system is supposed to work. The onus, if it's not a 524, the onus is on the Crown, and the assumption is release is what you go with, and then you go from there, and what's the least restrictive response? So focus on that. Focus on those issues. Is it a primary ground? Is it secondary? What is the issue? Certainly, if we speak about no alcohol clauses, there have been cases, I've certainly seen them, where if it's domestic related and the partner doesn't object to the person coming back but is concerned about alcohol use, it can be okay, you can drink, but not in the home. If you drink, you can't go home, which is a different kind of response. Some cases, if the person's living alone, it's if you drink, but you can only drink at home. I mean, again, these have to be relevant, but you can think about, is there a need for a blanket abstention clause? And usually there never is. Also focus on those grounds and then look at the systemic factors. So again, why is the person not shown up? Because they can't get to court. That's a systemic factor. That should not be used against the person when it comes to talking about bail. And then again, as I mentioned earlier, refer people back to Gladue. I find it actually is very helpful to remind courts about what the Supreme Court says. Because people always say, yeah, of course I've read this. Sure. I'm not saying you haven't read it. I mean, I read a lot of stuff, but I don't remember. Like, I read it, but do I remember it? No. So remind people what the court said. And you know, again, this is, I really appreciate this. This is a lot easier said than done. The court system sometimes looked like an assembly line. I've heard it described as the sausage factory. Justice Iacobucci, in the report that is referred to earlier, speaks about, for Indigenous people, it's conveyor belt justice, you know. You're running through. Bail courts are busy places. People don't have time. And those are all systemic reasons why Indigenous people are denied bail and why they consent to conditions they shouldn't. At some point, we cannot change the system if we don't change the system, right? It's going to take, if it takes a bit of time, it's going to take a bit of time. And you're going to have to say, I'm sorry, this is going to be more than 5 minutes. We can't get it. We don't have a consent release. We're close to a consent release, but the Crown wants X, and I don't think it's necessary. And here's why it's not necessary. But it's only going to change, and I am not minimizing the challenges of trying to come up against the way local systems work, because they are very real. But that's the only way it's going to change. And the way to do that in some ways is to go back to first principles and say, well, look, this is what the court said in Gladue. This is enshrined now in legislation in 493.2. we have to do something about it. We can't just say, yeah, 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 and keep doing the same things we've always been doing. So a couple examples of getting it right, they're in your materials. One is Papaquash. Papaquash is the decision of, it's a bail review decision of Justice Nakatsuru, the Ontario Superior Court. Deandra Papaquash has a very challenging life. You know, there was a prior Gladue report for her that had been prepared for a sentencing, which was provided to the court, which provided some background about her life. But she was homeless. You know, she wasn't going to have sureties. And Justice Nakatsuru, in his decision, spends a long time talking about how unrealistic it is to expect her to have sureties or to be able to have these things because of the life that she's led. There was a significant change in circumstance. By the time it got to Superior Court, she actually had found some housing, which was significant. But Papaquash is an interesting decision as he goes through those systemic issues and talks about why he's not going to deny bail on that purpose. Chocolate, decision from the Northwest Territories Superior Court Justice Shaner. It's a case of Mr. Chocolate is being released, the bail release is to go home. His father, the potential surety, has a significant criminal record. And what counsel does is they get the father to testify about the fact that, and this is relevant in this context, he was a residential school survivor and was an alcoholic. And so for a long period of time, he wasn't able to parent his son, but he had a lot of trouble. But he has stopped, he no longer drinks, and that's why there are no criminal entries in his record after 5, 6, 7, 8 years, and why it's no point taking why the prior criminal record, which may appear to disentitle the person to be surety, shouldn't apply. And you should keep that in mind because, again, given the overrepresentation, mass incarceration, frankly, of Indigenous people in the justice system, it is not unusual to have sureties who will have a criminal record. And if you go, I can't use you because you've got a criminal record, that's a systemic issue as well. Now, you may not be relevant. It may be hard to be a surety if you currently have a matter before the court. I get that. It's not going to qualify you as the greatest surety. But the fact that you have a criminal record, it may be dated, that should not disqualify you. And so, again, we have to, those are the systemic factors that get in the way. And chocolate is a good example, I think, of getting it right. Okay, so I've left time, miraculously, I've left 10 minutes for questions, if there are any. Please, but into the mic.
Okay, sorry.
No, you're not there yet.
Well,
you have to get to the mic.
Close enough.
No.
Bail is not an isolated thing the way you've talked about it in regards to Indigenous persons, because I've only practiced around the Lower Mainland, and the issue is housing a lot of the times. So it would necessitate like a group together rather than a defense lawyer alone to be able to convince the courts on release, because you'd have to put into place some kind of shelters that people can stay in that would give them an address, group like you have with people who have mental issues that make sure that they get to court. Those all have to be worked together if you're going to make it a fair system.
So my response to that would be, and I take your point, it's an important point, is to say what you've raised is a systemic problem that prevents people from getting bail. And so the starting point is you could say, yes, it would be great if the person has housing, but we know that there is not housing here. And so if there isn't housing, the answer can't be jail. That's a systemic problem. What you want and you don't have, and particularly Indigenous people are facing the lack of housing, then that's a systemic problem. And again, go back to the question, why is it that people want housing? What is it that you want accomplished by housing? Housing itself does not answer the primary, secondary, or tertiary ground. It just ticks the box that says housing. So if you can't tick the box that says housing, what is it that you think housing is going to do? So certainly, and I don't know, I'm sorry about BC as much, there are bail verification programs in Ontario, largely Indigenous specific bail verification programs. So people are released and they report weekly to an Indigenous organization. Do they have housing? Maybe they will, maybe they won't. But as long as there's a place they can report to, the court's happy. So I would just say, I think you're right, those are real challenges. But that speaks to the systemic problems. And so you challenge the requirements because they are simply going to guarantee that a person's not going to get bail.
Certainly I believe in everything you're saying, but just by way of devil's advocate, just to bring out a different viewpoint, they're both here in Vancouver and in Victoria. There's been some controversies around catch and release, where once in a while, for example, they don't catch that someone has some significant mental health problems and he went out and hurt somebody else, or you have an Indigenous person who shot and killed a rookie police officer as a first day on the job. When those things happen, it just becomes lightning rods for, it's not that the bail system is too strict, it's too lenient. We need to push everything right back. I'm just wondering how you would respond to all of that.
Yeah, no, I think you're right. There's no question that those incidents are quite significant. There was a very well-known case in Ontario where someone on bail, an Indigenous person on bail, shot and killed a police officer. This led to a whole bunch of, again, part of this catch and release argument. I will say, in response to the Ontario case, there was an article in the paper that said the individual was released because they were Indigenous. I actually read the bail decision. That's not correct. What the judge said is, I'm not releasing this person until you give me, until they have electronic monitoring. They're not getting released. They were released on electronic monitoring. What no one wants to talk about is what happened when the person obviously did something to the monitor. No one wants to talk about what the police did, what the monitoring firm did. No one wants to talk about that. They want to talk about, oh, he got released because he was Indigenous. There's no question that we hear this language, and it is, what is infuriating about it, it's not helpful, but it's infuriating, is that people are making assumptions that Bill C-75 has let all these people out when there's no evidence that that's the case. And in fact, the most recent evidence is that there are more people in custody now on remand than ever before. So are bad things going to happen? Yes. The response can't be that we lock everybody up, because we don't have the capacity to do that. So I understand, and I know how hard it is. I mean, I appear regularly before committees of Parliament to talk about these issues, and sometimes I just want to go, thank you. I'm going to take my 10 minutes by hitting my head on the table, because, and if you think it's bad now, anyway. But I think we just fight back to say, look, these things are they are tragic. But was there any reason to think, any reason to assume that anyone had any sense this would happen? As long as, the real problem, one of the big problems in bail, and this has been discussed a lot, is this idea of risk aversion. And risk aversion in bail is often spoken about as, well, we're afraid that the person released is going to do something bad. But that's actually not the risk aversion that is really driving. The risk aversion that really drives this is the fear that Crowns have that if they consent to a release and something goes bad, they're going to have to wear it. And this is, I will just say again, I will refer to, I don't know enough about BC, I'll talk about Ontario. The position in Ontario, because I'm old, 25 years ago was, you're the Crown, you make the decision, and we support whatever decision you make. If it goes sideways, we're on your side. Now what's happened is there are more and more guidelines for Crowns. You know, you never consent if it's a domestic. This list of things. You make the decision. You are the Minister of Justice, the mini Minister of Justice, according to Boucher or whatever. You make the decision. But if the decision you make doesn't pan out, we're hanging you out to dry. And the other systemic issue, which is not one that you're going to discuss with the court, and again, I don't know if this is true in BC, but very much true in Ontario, there are a lot of Crowns who work on contract. They don't have security of tenure. Like they are, I'm sure, living in, what they want is a job, full-time job as a Crown. They're living in fear that something, the decision they make goes wrong. Like, that's scary. I mean, part of the answer, I think, doesn't happen. I think it should be senior Crowns who are in bail courts all the time. Senior Crowns, members of the union, they got jobs, they should be the ones making these decisions because they're really important decisions. Junior Crowns are scared and they're going, look, I'm going to resist everything. This is one of the reasons the bail courts take so long. I just have to be on the record saying no. Like, I just want to be clear. I've said no. You want to release them, it's fine with me. But I have to say no. And that's a part of, those are difficult issues. But those are some of the institutional things, along with, I agree, the sort of political dilemma that's there. But that's always going to be there. Because things are always going to go wrong. It's inevitable that things will go wrong. But I will say this. We do a lot of inquests at Aboriginal Legal Services, and a lot of the inquests we do are with Indigenous people who die in custody, and they die in custody on remand. And somehow, people who are on remand and die because they should have been released, that doesn't get the same concerns. People don't go, oh, that was a real tragedy. People don't want to even look at why people are on remand when they don't have to be on remand. And that I find awful. It is tragic. It is unquestionably tragic that a police officer or anyone is killed by someone, particularly if they've been released on bail. That's tragic. It is equally tragic, and in fact, I think statistically more common to see people die when they're on remand, either from suicide or from drug overdoses or something else, and we don't seem to care about that. And we need to, those lives count the same way. And I think part of my response to that is to say those lives count too, and we can't pretend that that somehow those decisions where people are in remand when they don't have to and they die in those places when they don't have to, that is also not equally as tragic.
I think we have time for one question there, Condessa, and then one here.
Okay.
To wrap up. Thank you.
So you talked about, when we were talking about false confessions, one of the things you mentioned was in one of the cases talking about how people plead out because they believe that they're not going to get a fair trial. And they're not wrong, if I'm being very frank. Also keeping in mind that Judge Marchand, or Justice Marchand is behind me. But, like, they're not wrong, and judges are only people. And my fear is, I guess, as defense counsel, is like, I don't want to be able to bring that up in a way that's going to cause a judge to kind of resist my position. So what's maybe a tip you have for kind of bringing that up in a way that hopefully a judge is going to be receptive to, because it is true. We know from the social science that, like, there's discrimination throughout the criminal justice system.
So that's a really good question. They've all been good questions. I don't like to pick my favorite question. That was my favorite question. I think it's helpful to talk to your client. We've had clients who have never had a bail hearing. They have never had a bail hearing because every time they're arrested, they are told to consent to their detention. And I think raising that to say to the court, you know, my client has never had a bail hearing. They've never had a trial. I mean, you take a minute and ask your clients how many people have had bail hearings and how many people have had trials. And in many cases, you'll see that it's never happened. And I think you can raise that. That's a way of raising with people. Here's part of the systemic issue. Here's the hopelessness that people feel. It doesn't mean that, you have to let them out after bail hearing or you have to acquit them at a trial. I do think about a client that we worked with for many years who was in for us, our Gladue Court in Toronto, and he had a bail hearing and he was released, and he couldn't believe it because he had never had a bail hearing because his counsel always told him to consent to his detention. He'd never had a bail hearing and he'd never been released. And it was so meaningful for him that someone actually thought he could be released because he believed that was never going to happen because it had never happened. And that was not you're right, that's not an irrational belief. And I don't want to be, I don't want to be negative, but for many, not all, but for many Indigenous people in the criminal justice system, everyone is on one side and they're on the other. I know your defense counsel and your defense, and that's the Crown, that's the judge, but for many Indigenous people, that is not how they've experienced it. There is a system, there are three people, and they all lead to the same thing. They don't get bail and they go to jail. And it's not because they're not sophisticated, it's not because they don't know what's going on, it's because they do know what's going on. What's going on is they're always detained and they're always convicted, and it's always done really quickly, and it's hard to see in practical terms what role any particular person plays. It's not just part of one whole system.
Okay, so last question we have on here. It's a scenario question. So this council's asking, if a 30-day jail sentence is stupid and defense seeking 15 days instead isn't advocacy, then what is the alternative? Keeping in mind that the clients this person often deals with are typically homeless and addicted in their addictions, so probation order will just lead to breaches and more jail.
Right. So that's a very good question. It's not really a scenario. It's reality in many places. So I think you talk to your client and you say, so what can you do? What do you want to do? And maybe it's, will you go see someone? And maybe it should be the bail condition is you go see the person at this organization. It's really important that we don't turn a 15-day or 30-day sentence into like this massive, you have to go to treatment, you have to complete treatment. Like let's be realistic. If you wanted 15 days or 30 days, you don't want to make it so hard for the person to go, I'd rather do I'd pick the 30 days. But again, you have resources. You heard Daryl was here. Talk to the court worker. Meet the court worker in your court and say, so what do we have for someone like this? Ask the client what they can do, what they like to do. And just say, this is what, as a sentence, this is what the sentence is. It should be go and do this one thing. And let me finish, because apparently I'm finishing. Let me finish by talking about probation just for a minute. Again, a lot of counsel think, and quite rightly, you're not going to jail, congratulations, that's great. And it is. Look at your client's criminal record, okay? They may have been on probation most of their life since they were 13 or 14. This idea that probation it's great, you're only on probation. Think about if you would want to spend 10, 12 years never being able to go anywhere without asking someone's permission. And it's not your mom or your dad, it's someone you don't know who doesn't know you. Probation is also coercive. It keeps people under the thumb of the state. People can't go to funerals. Like, people die in their home communities and they have to go to their probation officer who will say whether they can go or not. And they're going to go, so it's not a question of whether they're going to go. So think about it. Sometimes the answer is no probation. Often the answer is no probation. You see people get probation when they're already on probation. Like, you're already doing, like, what's this reflex? Like, it's like you hit my knee and it's probation? Like, how does this work? Like, we have to challenge that too. And with that, I bid you a fond adieu. Merci, thanks, Miguel.
So thank you so much to Jonathan for coming across the country, for being with us for 2 days in a row. Let's give him one more round of applause as he's running to the airport. All right, everyone, we're going to get started again. Without further ado, it is my pleasure to introduce the Honourable Attorney General Niki Sharma, and I will give her a warning that this podium discriminates against the vertically challenged. So we probably need some phone books to stand on for next time. Niki Sharma was elected MLA for Vancouver Hastings in 2020, and she is our Attorney General. She's a member of the Legislative Review and the Treasury Board, among many other things. She is a lawyer whose practice focused on representing Indigenous people, including residential school survivors. She's worked across BC as an advocate on climate policy and reconciliation, and she's been recognized for her work on combating racism. She was raised in the Sparwood, BC area and is a mother of 2. And she's lived in East Vancouver for over 15 years and has deep connections in that community. BCFNJC in particular and the Justice Council are very, very grateful to the Minister for her commitment to our justice strategy and all of the work related to it. Despite all that is on her plate, she always makes time for us through monthly meetings, on ad hoc requests, in the middle of the night. When we need her, she always answers the phone, and we're really grateful for that. She's an incredible accomplice, so please help me welcome to the stage Attorney General Niki Sharma.
Thanks, Amanda, for that lovely, lovely opening. You can see like this part of my head. Is that what we're working with right now? Hi, everybody. It's really great to be here. And I'm told that so far it's been going really well and that you've been really having wonderful lessons and sessions. So I look forward to taking my CLE hours, and it usually happens around December, on this course. So I just want to start by acknowledging that we're gathered on the territories of the Musqueam, Squamish, and Tsleil-Waututh people. And I'm honored to be here amongst many colleagues in the legal profession, and I see the Chief Justice and the Judiciary also represented. Because it's such an important topic. And the importance of our role as members of the justice system with respect to reconciliation and Indigenous people and how that shows up in our justice system. And I just am so pleased to be able to support the work of the BC First Nations Justice Council. You will have no doubt met some of the dedicated people, including Amanda, that are part of that Justice Council. I thought I would share my perspective as Attorney General and the work we're doing on the justice strategy and the importance of it to all of you who are obviously very interested in understanding the transformation that I think is underway with respect to our justice system in the province. And I'll start with gratitude of the work that happened, that is happening right now with the First Nations Justice Council and the strategy that we're implementing with our work under the Indigenous Justice Strategy. You are specifically talking about Gladue here today, and it's 25 years since the Supreme Court of Canada decision in Gladue. And in that situation, the highest court squarely addressed the crisis of overrepresentation of Indigenous people in prisons and the need for judges sentencing Indigenous offenders to consider not only the unique systemic or background factors which may have played a part in bringing the particular offender before the courts, but the type of sentencing procedures and sanctions that may be appropriate in the circumstances. And I know that in the intervening years, Gladue Reports have become valuable tools for not only the court, council, and Indigenous people, but I think I would say I've never practiced criminal law. I represented Indigenous people as a lawyer, and what I've seen over the last 2 decades really is a transformation in our court system on how to understand the colonial impacts of that system on people. And as a government, we have adopted under our Declaration Act the United Nations Declaration on the Rights of Indigenous People into law in BC. That was a step up from I think commitments that were made by previous governments in the sense of understanding that it's a ministry-wide, government-wide work that we're talking about when we're thinking about how we not just reconcile, but we understand what the rights of Indigenous people were and what happened over the intervening years since colonization. And that has been a government-wide project. We have been looking at every legislation that we pass to understand how it can align with our commitments under the Declaration Act. But most important aspect to that, and of course I'm speaking as Attorney General, is the justice system. We have a lot of work to do when it comes to that. And I just want to say that the First Nations Justice Strategy is our roadmap for that. I don't know how many people have ever taken a look at that strategy. Maybe put up your hand if you know about it, have taken a look at it. Okay. So a fair number of people in it sitting there. And really what it, at its heart, is a project between the First Nations Justice Council and the government, including, very importantly, justice system and public safety, to understand how we do two things. So one is to lessen the impact of the current system on Indigenous people that we know, and I'm sure you are talking about in great detail these last 2 days. And the second part is with track 2, the exciting idea of how you understand how Indigenous legal orders show up and how different ways of resolution show up and how our colonial system steps back when it comes to understanding resolution of things in our justice system. And I have to say that I really do believe that our system and the one that we've had has things to learn about Indigenous ways of resolving disputes, has things to learn about how reconciliation shows up through a justice system or through a resolving of disputes. And that has to show up in things like the criminal justice system. I had the great opportunity a few times to visit and attend at a First Nations Justice Court, when there's one in New Westminster, where I saw the collaboration that happens between Crown Counsel, the judiciary, elders, all of the support groups, where people are coming there to be sentenced, but they're being dealt with as a human being that has lived experience, that has experienced the impacts of the colonization on their person, and what can happen when you design a system that is better attuned to that person. And really, at the end of the day, we know that our justice system has a lot of work to do when it comes to that. You are all a key part of that. You all have a role to play in that, and I'm really glad that you're here to take in the lessons that you all can share about how to better do that. So the First Nations Justice Strategy commits specifically 4 lines of action, and specifically on Gladue services. So the first is to establish Gladue services, a Gladue service agency led by the First Nations organization, which is the Justice Council. The second is to increase the capacity and number of Gladue writers to ensure increased access to justice for Indigenous accused. The third is to develop education and awareness programs for Gladue. And the fourth is to formalize the process for Gladue reports. So we are seeing progress, and in large part because of the work like the Justice Council is doing and today on all 4 of these goals across the system. And it's through this leadership that we'll continue to see that. I also hear a lot of, when I'm out there visiting people in different parts of the justice system, I hear about the demand for Gladue reports increasing. And the idea that more people are seeing it as something that needs to be integrated into part of our system and needs to be taken seriously and present during resolution of claims. I hope you're all seeing that too. I don't know if you could just give me, if you are seeing that, and it's just like a hands up. No. Kind of, couple people. So you're not seeing that. Okay, so that's good to know, and maybe we can have a dialogue about that afterwards. So I would say that there are times where we know that investments and resources at the right time and place are going to make a difference. And part of the reason that the Justice Council has been supported and led so many initiatives to expand across the province through their justice centers, we're investing in there will be about 15
I think at the end of the year. So these will be centers that will be showing up in communities all across the province, where there will be Indigenous people in those centers representing and there to provide services for other Indigenous people that are encountering the justice system. I think that's a very key pillar to the work that we're going to do together, because that connection that you can have with culturally appropriate significant support by Indigenous people and communities across the province, where the right kind of services related to whether it's Gladue Report writing or representation or things that will help that person get better outcomes through the criminal justice system is just so key to some of the investments and the work that we see that we want. We are allies with the Justice Council throughout the province. And that should show up for people when they're going through sentencing, when they're going through different parts of the justice system process. I know that, and I've heard this before, about the need to make sure that Gladue Report writing and Gladue reports are available when asked and in a timely way. And I've been speaking quite a bit with people from all parts of the justice system about this, about how we make sure that once it's integrated and once it's and once people are asking for it, that you can get it in a timely way, that you have enough support in terms of the writers that are available to do it, the quality of the reports, the accessibility of them, and when they show up. And I know that that's like something of concern to people, that we are working hard at figuring out how to make sure that along with that expansion, we have that integrated pretty well into our justice system. And I think part of it is having you all here today. And I looked at the list of instructors that were leading some of the courses here, and I just want to say that I'm very in awe of the experience and the knowledge, the expertise of the group, and I know that it'll help us deepen our understanding of how this important tool can be used at different parts of the justice system. And I am really eager to hear any of your thoughts or ideas on that. And I find that I learn the most from people that are on the front line, that are experiencing and seeing things. So if you want to reach out and tell me about where you're seeing gaps or where you see things could get better, please do that. I was asked to speak a little bit about what, as from the lawyer's perspective, representing Indigenous people in the system that we have as our justice system. And I did that for many years before becoming Attorney General. And I have to say that it was very clear to me, and I think it's probably clear to a lot of people that the tension that exists already between an Indigenous person and the colonial justice system, and the ways that we resolve disputes, and how it was a system that was used so effectively against Indigenous people for so long. I learned a lot of things just from that. And I remember being a naive articling student stepping in to work at that point that was litigation related to Indigenous or to residential schools, and not even knowing a fraction of the history that Indigenous people faced. But I also remember learning pretty directly about the gaps of understanding that our law and our common law and our court system had when it came to dealing with that history. And how it was so much on the shoulders of survivors to have the courage and the strength to come forward in this system that, I mean, they almost knew at the outset was not going to hold them properly. It wasn't going to understand and resolve things in a way that was going to bring, I guess, the closure or peace of mind that people sometimes think the justice system should when they're coming forward, and this idea of what justice means. And it was really something that I will carry with me for the rest of my days, because I learned way more than I think I was able to give, although I hope I was able to represent them as best I could. And that's what we hold when it comes to the path of reconciliation in our justice system, the idea that if we want to have a system that works for people and understands the impact of colonization and understands the long history of pain that people carry when they're before a judge in a criminal matter, when they're before, whether it's a civil claim or any other claim, when they're before that and trying to get a resolution to their matter, trying to be treated fairly in a system where we know that racism exists, is that is a challenge that we in our legal profession and the judiciary carry with us every time that there is an Indigenous person before in a court matter. And I know that that's something that the profession is taking seriously more and more every year. I see that transformation, and I just want to say that I think it's one of the best things we can do to make this province a more just place is to understand how to do that well. So your commitment on that, I think, is really important. I think that there are key things that, as a government, that we need to do, and I talked about a little bit about the transformation in the justice system through really supporting as much as we can, and I take that role very seriously, the Justice Council, and expanding across this province. And I know that they connect with a lot of people through that work, and I just want to say, and maybe before we go to question and answer, if there are any that we are on that transformation path. I really do firmly believe that. And I know that there are a lot of challenges when it comes to understanding how to do the work case by case, to understand how to get the resources at the right time. But I see a high level of commitment by people not only in the Justice Council, but the judiciary, by lawyers. I see that, and I hear that from many people. So we're going to be able to work through the challenges that I know we're talking about today, about developing our thinking of how, as professionals, we show up in a different way. And we're going to move to a system, the track 2 of the justice strategy, which is, I think, really exciting to me about what a justice system looks like when it resolves disputes in different ways. That are from Indigenous laws or Indigenous ways of resolution. I've had a chance to see the impact of that, whether it's a child custody issue that would normally be dealt with maybe in a way that causes more trauma to people, instead in a way that brings people together and holds a space for accountability in a different way. And I've seen that, and I've been taking those lessons, and I think about how we think of our family law system in BC. So I just see a lot of potential on this journey. Although it takes a lot of commitment, I want to say that I know that we're on a journey together because I see it and hear it in the profession. Maybe I'll stop there and see if there's any questions that anybody has of me, or discussions or things that I could learn from you on what you're seeing.
I'm very excited about the justice strategy, so I share in your enthusiasm about that. I'm finding in my negotiations with Crown Counsel, for the longest time, the Crown Policy Manual has been one of my strategies, and I think one of the most successful strategies as a defense counsel, to use the Crown Counsel policy manuals to point to specific policies where I can convince Crown, see, this is exactly what your policy says, so please accept this resolution. I'm not finding that being able to point to the justice strategy is transforming in the same way, even though it is a joint justice strategy. So I'm wondering if you have any thoughts about how, and especially when it comes to track 2 work, that's really absent from things like the Crown Counsel policy manual. So I'm really eager to see if there will be changes to that policy manual to reflect the justice strategy.
Yeah, I think that's a really good question, and I think we have a lot of work to do to understand how it shows up and how it integrates, and because really when it comes down to it, it's up to this kind of individual decision making with Crown prosecutors, right? And so you can have these like beautiful policies that talk about how things should be done or shouldn't be done, and then is the right kind of training and decision making and tools in that right moment being used or accessible or understood. And I think that's the journey we're on. And I'm not saying it's an easy one. I know the Justice Council's been doing some pretty amazing trainings, like directly with different parts of the judiciary to understand how people can incorporate that. The question about track 2 and how it's showing up is also a very good one. I think we're at the very preliminary start of that journey. And Gladue maybe is one that's been around for a while, but this idea, I think, of how we resolve disputes or how we respect Indigenous legal orders or Indigenous ways of resolving things, we have a lot of work to do on that. There's no, I don't, there's a way to sugarcoat that. We just do, because the the conversations that I'm having with different nation governments are all different, and some are pursuing that through treaty. So they're pursuing justice and up to like figuring out how to set up a court through their treaty negotiations. Some are at another stage where they would like just there to be better enforcement in the existing judicial system of Indigenous law, so recognition by any provincial court judge or whatever that this is a law, which, then the first question is, well, what are they? Like, how can we revitalize them in a way? So I have different conversations with different people about that, different governments about where that journey is. So then the next question is, well, once we've established the different ways of resolving disputes that are showing up, how do existing structures like Crown Counsel, who are very embedded in a certain system, or the judiciary, when this shows up in a courtroom, how do they take it into account? So I think, just to say, I think we have a lot of work to do on that second track that to me, hopefully in the next 5-10 years, we'll start to see how that integrates well. Yeah. Thanks for the question.
Good morning, Attorney. My name is Brenda Edwards, and I'm the chair of the BC Review Board. And my question to you, I guess, is how the First Nations Justice Council and the Justice Strategy contemplates dealing with people that appear in front of the BC Review Board. In my humble opinion, we are the forgotten end of the review board, of the justice system. Individuals that have been found unfit to stand trial or not criminally responsible are also Indigenous in numbers exceeding their representation in the population, but it is extremely hard for us to either get a Gladue Report or, I imagine, more difficult for the Gladue Report writers to be able to come to us with any kind of a strategy that is going to allow the board to release that individual on a conditional discharge versus being held in custody. And while you might end up with a criminal sentence that's 2, 3, 5 years, we have individuals under the review board that have been there 50 years. And because there's nowhere to discharge them to that can manage the risk that they pose, because they not only are dealing with all of the factors that normally appear in a Gladue report, such as individuals that have been subject to residential school or have grown up in families that have been subject to that, but also are dealing with a mental disorder, such as schizophrenia. And when you add that on as an overlaying factor, it just seems to disappear off the screen. The only time I find that the review board gets any attention is when something goes wrong. And we would like to be at the front end and the proactive end of being able to plan for things to go right for the individuals that we'd like to release.
I mean, that's an excellent point, and I have to say, I think that I can just speak for myself. I've been thinking so much about how we are talking about the criminal justice system or other systems and how we're implementing on those, that the review board was not something that I've personally thought about, but I think your point is a really excellent one. So I guess what I would say to that is let's have a follow-up meeting to talk about that. And I'm very happy to do that.
So I think sometimes it's really difficult when we talk about these really great ideas about like giving life to Indigenous legal orders, to kind of creating healing plans. Those sound lovely, especially somebody who tries to do that in my work. Like as a defense counsel, that's really something I strive to do. The problem is, and particularly with the youth, is that the lack of Indigenous-based resources that are culturally appropriate, that are nation-based, don't exist. Like the social science research tells us that like with the Youth Criminal Justice Act, that there are actually a higher proportion of Indigenous youth incarcerated now, as opposed to the Youth Justice Act. And that's because all the programs don't exist for like Native youth. So like we're actually getting more Native youth that are incarcerated as a result of the Youth Criminal Justice Act. And the rate of non-Indigenous youth has gone down. And so, like, I think the problem we have, and this is just a comment, is that, like, communities don't have the resources, you know, under the thumb of the federal government, because that's kind of, you know, that's the jurisdiction, is they don't have the resources to create these, like, programs that everyone wants to use. So it's kind of like, sometimes it's like we have great law that ideally can be used to do all these wonderful, lovely things, but we don't have the resources in the communities to do that. And so I mean, it's more of just a comment. Like, it makes it really hard, I think, as defense counsel to come up for us with these really great, you know, creative ideas to get our clients released. But the result right now, without the resources to back that up, and I mean, it's a larger problem with mental health as well, and I think that was touched on by Brenda, is like, people don't have the resources appropriate. Like, there aren't, like, treatment centers sometimes that'll take somebody who's got a K file, or somebody who is, like, severely schizophrenic but is also addicted, or they're not culturally appropriate, and there's certainly nowhere to send anyone who is going to get rehabilitated for a sexual offense. Like, there's nowhere to send them. There's, I think, you know, Vision Quest is one of the only places you can send them in the province right now. It's devastating. There's nowhere to send some of these people depending on their needs. So, I mean, I don't know if there's, like, I don't know if I have a question. It's just a concern I have. Like, it's really difficult to do our job without the resources that are appropriate, because, like I said, we're seeing the rise in the disproportionate rates of Native youth incarcerated, especially in British Columbia.
Are there things that you put in that plan, or specific parts of the province that are a higher problem, or is it just? It'd be great to learn, like, what are the things that you're asking for? Is it the treatment? Is it youth specific, based on mental health resources and?
I mean, the reality is that in a lot of those cases, it's kind of across the board, right? So when we saw the deinstitutionalization of mental health in the 90s, right, there was no, like, community-based programs that replaced those programs, which is why, you know, a lot of criminologists, like, theorize that we have this, like, really big problem of, like, mass homelessness now. Because there isn't somewhere to send people. I mean, it's really hard to get somebody apprehended under the Mental Health Act. So it's like, I have a family member can become severely delusional. And it's scary and it's frustrating. It takes up everybody's time. And, like, not every family has the resources to deal with that, and there's nowhere to go.
Yeah, you know, thanks for raising that. It is a big issue in the province. The last budget, we put $1 billion in expanding mental health and addiction services across the board, because I think there's a system of care that was kind of slowly broken down, and you named some of the resources. So Redfish is one of the new, but we need to do a lot more work when it comes to investing in them across the province. And figuring out where they stand up. And as a government, we haven't been, the thing that always used to get me, especially when I was practicing, is jurisdictional fights between the federal and provincial government of who should resource things. And we as a government have just been like, no, if the resources need to happen and it's on reserve, it doesn't matter. So I think we were the first government to build housing on, a provincial government to build housing on what would be the federal jurisdiction land. So I think that there just is a need to step up. One of the challenges that we're facing with expanding, which is just, we're figuring out ways to solve it with mental health and addictions resources, is the HR challenge, because we have the money for the beds in the different parts of the province and are investing in that, but we need a big influx of people with that specialty skill set to deal with mental health, and can have the skill set to support them. And it's the exact same pool of people that are in healthcare and the healthcare challenges that we're having in HR. There's a big crossover there. So we're trying to find ways to upskill people quicker so they can get to those services. But that's what we're seeing about building up that system of care, but it's 100% right. So and it is, I can see, like, if you come up with this plan as defense counsel and there's nowhere to put them, then the plan doesn't mean anything, right?
That's good.
Oh,
yeah.
Okay.
No, there was a couple on here, but one was kind of rhetorical, but it was, what does justice mean to you?
What does justice mean to me? That's a big question.
Yeah.
You know what? How I think about it is that everybody deserves a fair process. You can't guarantee outcomes in the justice system. You all know that because you're working with it, and that's always tough as a lawyer because you really think your case is the best case in the world sometimes, and you're and then when you lose, it's devastating. I've experienced that. But everybody in BC is entitled and should be entitled to a fair process where they are heard and they have an opportunity to heard in a timely way. And they have a judiciary that is independent, that can deal with their case in a way. And that to me is my role as Attorney General, is to figure out how we get there, that fair process. But that embedded in that is a lot of things, right? It's racism, it's inequality, it's all the things that people experience that make it so processes are maybe on their face seem fair, but actually aren't underneath that next layer of what they're facing. So I guess I would say I'm always thinking about that. A justice system is something that it has a fairness aspect that treats people fairly, and that they're understood in terms of their barriers. We're doing a lot of work on anti-racism in my ministry, and we've introduced legislation on that because I think there are embedded systems that are in our structures that work against people that we need to target, because that's part of building a fair system. So I'd say that.
Thank you.
Okay. All the best for the rest of your sessions.
So thank you so much to the minister for joining us. Just in addition to her reply on the issue of resourcing and community-based programs, I also wanted to mention, so the government of British Columbia did make a $10 million commitment last year to BCFNJC. So we have funding available, and Corey mentioned it yesterday, for BC First Nations communities to either under Strategy 15 grow their community justice programs that exist, or come up with a justice plan with the support of BCFNJC staff. So that work is ongoing. We have staff. The HR issues are real in healthcare and justice, but we have staff in our Bundle G that are actively working on that. But it's just a start. It's $42,000 per community. $10 million sounds great, but there's a lot of First Nations here. So it's a first step. And the idea with Strategies 15 and 24 is that there will be ongoing commitments from, of course, both the province, but the federal government as well. You know, the Indigenous justice programs across British Columbia have been chronically underfunded, and they need more resources in addition to creating new programs. So, you know, this is work that we're really proud to do in partnership with the province of British Columbia. And I thank you so much for making the time for being here today. Miigwech.
Now I have the pleasure of being able to introduce to all of you some of our GSD team, so Gladue Services Department. They're going to be speaking today on the trauma-informed practice and preparation and presentation of Gladue reports and for sentencing, as well as speaking about the healing plans and aftercare program. So we have 3 people with us today. We have Jennifer Isaac, who is a seasoned Gladue report writer. She's come to us today from Prince George, so she made the trip down, and she's been writing for quite some time. We also have Olivia Thomas, who's another Gladue report writer, and she also came in from Nanaimo. We also have Jackie Stalkaya, who is our Gladue support worker lead. So the difference between that versus the writer is she works on the healing plans and the aftercare and support work throughout it. And they're all going to be discussing today about the process about putting together the reports from start to finish, and how they work together and how that material goes before the courts. So welcome.
Hello, my name is Jennifer Isaac, and I'm really happy to be here. Excited, a little bit nervous, but we'll get through it. And I'm a member of Nakaslii-Watan First Nation, and I currently reside in the Lheidli-T'enneh territory, also known as Prince George. I have been with the BC First Nations Justice Council for approximately 3 years.
Jackie Stalkaya. I come from the Syilx territory. I'm a proud member of the Osoyoos Indian Band. I've been with the BC First Nations Justice Council since June of last year. It's been a wild ride with the support work program, a relatively newer program. I think we're in our 2nd year now, but it's a really, really great program. I love working with the rest of the GSD team and the writers, and I'm just very happy to be here to share our experiences and our knowledge.
Han, Shina Kamana Skawi Imachia, Olivia Washichu Imachia. What I said was hello. My name is White Shawl Shell Woman. My everyday name is Olivia. I am a member of the Sioux Valley Dakota Nation, and I've worked with the BC First Nations Justice Council as a Gladue Report writer since May of last year. And I just wanted to share with everybody today that in Canada, I was told by a relative that Dakota people actually call what translates to BC, translates to the source of the sun ocean. And I thought that was really beautiful. And I wanted to share that with you today. And I could say it in Dakota, but I'm still learning the pronunciation. So thank you so much. I'm really happy to be here.
So as Gladue Report writers, we are guided by a set of core values. Those values are culture, safety, respect, empowerment, trust, and results. Through these values, we are able to create cultural safety and understanding of the individual's personal and unique experiences. As a First Nations Gladue Report writer who has experienced these systems of oppression that we write about, I'm able to understand the value of these core principles implemented when assisting in Gladue Reports. We can bring opportunity of culture, safety, understanding, respect, self-determination, trust for the individual and the First Nations community that we interact with through the Gladue Report process and the sentencing process for persons served. So, next slide.
So that's my slide here. So the role of the Gladue Report writer, it may be clear after all the discussions yesterday, but I'm just going to go over it a little bit again. So as a Gladue Report writer, you know, we obviously provide the court with a Gladue Report. That's a comprehensive understanding of an Indigenous offender's, you know, unique circumstances. And they all have unique circumstances. No story is the same, although they all are very similar in experiences, but they're all differently impacted. So, you know, we take a deep dive into their life, and not only just theirs, but their families. And that can take, you know, a large majority of the process is gathering the information. So, you know, we want to see how they're impacted intergenerationally throughout their family. And by highlighting their experiences of their intergenerational trauma and their factors, Gladue factors that we call them, it assists the court and the sentencing judge in crafting a fit sentence for them, just for them, that person. And it helps in not only making an informed decision on their sentencing, but it promotes culturally sensitive sentencing decisions. It acknowledges the distinct considerations that are applicable to Indigenous offenders. And as Gladue writers and support workers, we do not advocate, per se. We are trained to ensure that each Gladue report or Gladue letter is written accurately, neutrally, and without advocacy. However, the support worker can be a little more of an advocate than us because they're doing a different role. Thank you. Next slide.
Okay. The Gladue writer education and qualifications. So Gladue report writers come from diverse backgrounds. Many Gladue report writers share backgrounds in law, criminology, sociology, social work, and among many others. And as a Gladue Report writer, we have ongoing training and education initiatives regarding trauma-informed approaches, education and understanding of how to present the Gladue factor information for each Gladue Report. We also have internal training such as learning criminal language, court language, disclosure information, and how to write Gladue Reports, healing plan training, and other specific training for Gladue Report writing. As Gladue Report writers, I also wanted to mention we are not advocates and must remain neutral and unbiased in completing our Gladue Reports. As a First Nations Gladue Report writer, prior to this role, I obtained a Bachelor of Social Work with Indigenous specialization. This has helped with my own personal experience of being First Nation and a social work kind of background as well has helped me in writing Gladue reports. I find it very helpful. And as a Gladue report writer, we are working to change the criminal justice system and bringing forward Indigenous healing options, and therefore reducing the need to rely on custody as the only option for our people. So, next slide.
That's me. So, again, just to reintroduce myself, Jackie Stelkaya, team lead for the Gladue Support Work Program. I don't know if you all have heard about the Gladue support workers, but you will today. And so our role as the support workers in the Gladue Services Department, we work alongside the report writers. So what we do, we firstly provide practical and emotional support to our clients throughout the Gladue process and along their path to healing. We know the Gladue report writing process can be really traumatic for our clients, which is why we always try to take, a very trauma-informed approach. But like Jen and Olivia said, less advocacy on the writer's end. That's where the Gladue support worker can come in and support these clients in the way that they need throughout this process and afterward. So we are also responsible for creating the healing and restorative justice plan portion of the report. And again, this is a collaboration with the client. We don't do it for them. We want to do it with them. So that we can focus on repairing the harm that's been done, but also supporting the client with their mental, emotional, spiritual, and physical well-being. As well as support workers, we immediately begin to liaise and try to eliminate any barriers that our clients might face when crafting their plan, so that the clients can begin to engage with these resources and enroll in programming immediately following their first interview with the Gladue report writer. And in doing this, it aims to help reduce the recidivism, promote risk mitigation, and decrease victimization. Increase rehabilitation and community safety, and to demonstrate to the courts the immediate measures that an individual is taking to address their factors and to demonstrate the effectiveness of their healing plan and to essentially move forward. And so further to addressing an individual's Gladue factors, an important piece of these plans as well that we must focus on, and I know you guys are probably all wondering, but we also need to address the index offense. We're not writing plans to completely ignore the situation at hand, but it also depends on which point in the life of the file that the report is requested. So I'll touch on that a bit later. But yeah, as Gladue support workers, we become a revolving support to these clients, and we'll adapt with them the healing and restorative justice plan resources based on their current circumstances, and sometimes always ever-changing circumstances, and just to ensure the continuity of their healing journeys. So thank you.
Okay, so eligibility screening. The Gladue Services Department has crafted a set of screening questions designed to address situations where there is a deficiency in documented membership or supporting evidence to Indigenous heritage. So some eligibility questions include specific information regarding the Indigenous experience, and although we are unable to confirm or say if an individual is Indigenous or not. Okay. Yes, sorry. If Gladue report writers are unable to identify the connection through these questions, we approach our immediate supervisors, managers, or the director of Gladue, and then we kind of work together to kind of come to a kind of agreement or what kind of information seeking on where we should kind of go next with that information. So that's kind of that. And then the initial research. So interviewing the person served. Information gathering in a trauma-informed manner. So at BCFNJC, we take a trauma-informed approach to interviewing and information gathering. So the trauma-informed approaches are understanding the experiences of Indigenous people as a whole in Canada and preventing further harm to the person that we're writing Gladue reports for, creating safety and reassurance throughout all interviews of self-determination of an individual story. So as a Gladue report writer, I will always ask the individual before our first interview, after our interview, and then upcoming to our second interview, because I'm an overthinker, so I'll ask if this person, like, did you kind of lay awake at night thinking like, oh, maybe I shouldn't have said that, or because that's how I am. And so I always kind of ask multiple times throughout the interview process, like if there's anything that you've thought of that maybe you don't want to include, we can always take it out. Or if it is, if I feel like as the Gladue report writer, it might be kind of important information regarding their experience and kind of what brought them in front of the courts, I can kind of explain that in a way like maybe we should include it, but we can say it in kind of this way, or things like that. We always kind of want to make sure that the person is in charge of their story because it is theirs, and in having an understanding of like the process and things like that as well. So, and then we also have we include social workers, family members, support workers in the interview process to support the individual, because we know that these interviews and telling your story sometimes for the first time is not always the easiest thing to do. So we always want to make the people as comfortable as possible. And then for people, the individuals who are in custody, they have options for having a support person kind of talk to them after in custody. So whether that be an elder or I think they're like the Indigenous liaison officers who can speak to the individual after if they feel the need. So usually in Gladue report writing as well, throughout the interviews and stuff, rapport is built, and the individuals can always come to us about any issues that they may be having. One of the first healing plan options we usually try to get in place is counseling, because we know that it would be helpful, especially for the individual, to be in counseling after speaking about their experience. And usually everyone wants counseling, so I know I need it.
Not that this process causes someone to need counseling, but it's just an added, support measure. And a lot of people will realize through that process that, counseling might be good for them. Mm-hmm. In a positive way.
Thanks, Jackie. Yeah, so in sensitive information gathering, we want to make the individuals as comfortable as possible. And sometimes the rapport is needed to be built before we can get to that information in a good way. So we never actually want to pull the information, but eventually the people do start to trust us a little bit because they know that, we are, as a First Nations person, especially, I've experienced these as well, so I do kind of explain that as well, and I'm able to explain my experience, which I find is quite helpful as well to some people. And I guess one thing that we do worry about is I've been in courtrooms where Gladue reports have been read out loud, and sometimes this can be very traumatic for individuals who have not told their story. I know that someone kind of talked about this earlier, or yesterday, I think, and so I was kind of happy that someone else said it, because it's happening and people are worried about it. So thinking about how this person may have not told their family members or they don't know what happened to them, and if this report is read out loud, it can have some uncomfortable conversations for the individual, especially with family members, and if they said stuff about their family specifically and maybe they don't know that they feel that way. We kind of are in hopes that it won't be read out, but we do add if there's a specific part that the person doesn't want read, we will include like a little kind of excerpt before this certain section to kind of create safety and understanding for that person, knowing that, hey, this part will not be read out, or we hope that it won't, but we can't actually guarantee. So yeah, that's the interviewing the person served. And then we have interviewing and information gathering. So interviewing collaterals. So that's family members, friends, employers. I've interviewed, sorry, I'm just gonna grab some water. I've interviewed chiefs of First Nation communities and employers as well. Like it can be really helpful to the person's story to interview family members and friends, because they all kind of have a different experience of the person, and they can include different information that the person may not remember as well, and just kind of seeing their life specifically from a different kind of angle, so they can understand a little bit differently how this person may have been affected by these things. So that can be really helpful. And then, yeah, it's collateral, so family members help with the residential school experience if they can't remember, or the grandparents, things like that. Friends can be really helpful to see the recent changes of the individual. And then employers are helpful to comment on work ethic and any changes they can identify as well. So I also wanted to talk about the helpfulness of lawyers in the kind of Gladue Report process. So lawyers can be really helpful in getting contact with the individual. Sometimes we have the wrong numbers, or they've changed locations, especially in custody as well. So the lawyers can be really helpful in helping us find the individual so we can start the Gladue process. They can also be helpful in understanding the information we are seeking and why, so that will help complete like a fulsome Gladue report for the individual. And then lawyers can help facilitate the process of the Gladue report, and calling, so lawyers, yeah, they're really helpful. Sometimes we can't get a hold of people. Sometimes people are worried. Sometimes I've had people kind of come forward and say, well, I want to talk to my lawyer first. And I'm like, okay, we can do that. Like, it's no problem. And so being able to, give information to the individual before they start the Gladue report, explaining kind of what the Gladue report is, what kind of information is needed. And then also, yeah, managing expectations of the individual, and even bringing up like, hey, they're going to want to maybe talk to your family members or your friends or your employers. So I would start maybe thinking about that, and so they kind of have an idea of who they want us to talk to when we do start interviewing. So next slide. Okay, so this is a Gladue letter versus Gladue report. So the Gladue report is approximately 10 to 15 pages. We want to talk to several collaterals if possible, a long personal history of the individual, kind of from the first memory up until the offense, more in-depth narrative with chronological timeline. Each of the sections is several pages or paragraphs, in-depth academic research, and uses more quotes. Whereas the Gladue letter is 7 to 10 pages, only has about 1 to 2 collaterals, a short personal history, and then organized by Gladue factors. So that's in subheadings, and then each of those are about 1 to 2 paragraphs, minimal academic research, and then minimal quotes.
And I just want to touch a little bit right now, as I know we discussed yesterday with Amandeep, our director, about the reasons behind why there may be a Gladue letter versus a Gladue report requested or written. So some of the reasons that this may happen is, a defense or a crown may request a letter versus a report due to the, a shorter time limit or time frame before sentencing. If a sentencing date cannot or doesn't want to be adjourned, we can complete a letter in a much shorter time frame. And in this case, it might not be ideal or possible, considering how soon the sentencing date is. Now, letters can be written extremely quickly if absolutely necessary, but only with the availability and commitment of the person served, our client, and the engagement in the interviewing process. So secondly, if a person has a very complex personal circumstance happening for them that leads them to be unable to be meaningfully interviewed or engage in the process, such as being in extremely active addiction, unhoused, no access to a phone or what have you, a Gladue letter is more appropriate, and we can rely heavier on the collateral information, people who know them and who are involved with them, versus trying to force them to get on a phone, get to an office where there is a phone, try to have an interview, which maybe they aren't even able to do or to contribute meaningfully to. And so thirdly, if the person is a youth, a lot of times a letter is also easier to complete, because often youth, aren't willing or ready in the same way as an adult might be to engage in the Gladue process, because as we've mentioned over and over, it's not an easy process. It's hard. I'm not going to lie to you, it is difficult for people to go through this, especially if it is the first time that they've ever spoken to anybody about these things, right? And so lastly, if a person served requests a letter versus a report for any of the previously mentioned reasons, we would probably honor their request, because again, we are pro self-determination and having people have a say in their choice, in their story, and how it's written and how it's told and given to the courts. So all of the components in a Gladue letter are actually exactly the same as a Gladue report. It's just a little more condensed. So that's basically the only difference. It's just a little shorter. That's it. It's all the same thing. Thank you.
All right, so the purpose of the healing plan, you heard me refer to it earlier when I was speaking about the role of the Gladue support worker. So we actually contribute a little bit to the report as well. It is the healing plan and restorative justice considerations portion of the report. The purpose of the healing and restorative justice plan is to showcase to the court the collaboration that we are doing with the client to identify rehabilitative programs, services, resources, and agencies that our clients can utilize, and then propose these to the courts as an alternative to custodial time, which is it's a really important piece of this person's experience and where they are at in front of the courts. And these programs that we find, these services, these resources, these agencies, we try to find relevant programming to support clients with their mental, emotional, physical, and spiritual well-being, while also focusing on repairing the harm. So we're not just going to grab any program we can to throw it in there to make it look good. We go further than that. And examples of these programs, restorative justice programming, counseling. There are many different forms of counseling. We go a step further, we explore with this person their experiences, and we may target specific areas when we're exploring counseling programming with our clients. Again, counseling, we can target if this person was abused sexually, if they were abused as a child, if they've had childhood trauma, grief and loss, substance counseling, substance abuse treatment. We have to get specific and we have to get creative. Employment supports, housing supports, cultural programming, healing circles, sweat lodge, ceremony, land-based healing. It's all relevant. And as Gladue support workers, it's also very important that we respect our clients' right to self-determination, but we still need to encourage them to take a deeper look into their factors and consider these programs and how participating and engaging in them will support them. Yeah, we really respect everybody's right to self-determination, but a little bit of coaching didn't hurt anybody. Thank you. Oh yeah, it's me still. All right, so I love this. So while we craft a healing plan, very difficult process, but again, we have to consider a client's Gladue factors, and you've heard this over 2 days. I will let you know what those Gladue factors are. I have a list. But anyways, so when writing a plan, it's important to consider a client's Gladue factors and the impacts that colonialism has had on their life and how these impacts have contributed to this person's current circumstances and the index offense. So while we're crafting a plan, we explore the information that was gathered by our lovely Gladue Report writers and identify the factors that are most currently impacting this client. Personally for me, when I look, when I'm working with a client, what I try to look to identify first is, are this person's basic needs being met? We all know the traditional basic needs of an individual are food and water, shelter, clothing, transportation, income, healthcare. It's not an exhaustive list, but these are what I look at to consider before I even try to suggest to somebody, hey, you know, you're unhoused, but why don't you go do this? Or, you know, why don't you go to this program? Or you don't know where your next meal's coming from, but, you know, why don't we enroll you in this? That's not realistic. We see it a lot with other kinds of plans out there. But we have to focus on those basic needs first. We all have heard that if your cup's not full, you can't fill everybody else's cup. Our clients' cups are a lot of the time extremely empty, and it's our job to just reduce any kind of barriers that they're facing and try to get those basic needs met so that they can take the next step in this journey. Yeah, and if we're not addressing those basic needs, the chances of crafting a successful plan are significantly reduced, and their success rate is not going to be existent if we're not addressing those pieces. So as Gladue support workers, it's our job to identify our clients' needs and to aim to immediately reduce the barriers that they're currently facing, which I literally just said, sorry. But after identifying these needs, we also really encourage the client to consider the Gladue factors and to begin to collaborate on ways to address these factors. So collaboration, and I think I've said it now, this is probably the 4th time, is such an important piece to our work, to our writers' work with the clients, to the support workers' work with the clients, to lawyers' work with the clients. Collaboration is key. And for us, it's an important piece of this plan, because when we are collaborating with the client and we're giving them a voice and we're supporting their right to self-determination by also coaching them a little bit but supporting them, you know, it showcases their accountability, they're holding themselves accountable, and the motivation that they have to heal and move forward in a healthy way. I cannot tell you how great it feels to have a client that I've been able to build a rapport with, who is really eager and willing and wanting to do anything and everything that they possibly can to change their circumstances, and the only thing that's in their ways are the barriers that we all know and hate. I was going to say love, but we don't love them at all. You know, and it's really gratifying in my role as well to be able to support our clients, be with them shoulder to shoulder and get them moving, help them in the right direction. And so back to these Gladue factors, it's hard personally for me to sit down and consider, you know, everything that I have been through or everything, you know, that I've experienced. And, you know, for our clients, it's very similar. They don't want to sit down again and with me anyways, and really discuss their Gladue factors. So we usually, we have a referral process. Not every client wants to enroll or participate in the Gladue Support Worker Program, which is fine. But on our referrals from the writers, we get referred to, the clients get referred if they're willing to participate. And the referrals will have the pertinent information from the writers on these Gladue factors so that we don't have to question our clients again, over and over again. And anyways, sorry, I went on a little bit of a tangent. Examples of these interventions that we're trying to find and narrow down and get our clients connected. Individuals who have been charged with substance-related offenses, obviously we're going to try to engage them in substance-specific programming. Individuals with violent or behavioral-related offenses, engaging in obviously behavioral programming. Individuals with sexual-related offenses, engaging in sexual programming, etc. But an important piece to note is that we do support clients who have a long history of involvement in the justice system, and that creates a bit of a challenge for us to collaborate with our clients to identify why the conventional programming that they have participated in previously has not always been successful. This is where creativity comes in, and we have to get creative in our collaboration with our clients. And one thing that I'm very happy to say is that we are experiencing much success with incorporating Indigenous culture and community into these plans. And I'm going to go back to conventional programming. Conventional programming is not Indigenous based. So many conventional rehabilitative programs that clients have participated in lack an Indigenous component, and it is an important piece to note that in every plan we craft, we not only try to include culturally relevant and specific program components, but we do this to support Indigenous right to self-determination and autonomy. When an individual is an active part of their Indigenous community, we strive to not only incorporate culture, but we consider and explore the laws and legal traditions of that specific community, and we try to include these measures for the courts to consider as an alternative. Why not? In cases where clients are facing disconnection from community and culture, we try to work really hard together to create, repair, foster the connection once again. I have found that conventional resources and services programs focused on intervention do not always need to be prioritized as well in these plans, as there are other more relevant resources to consider for our clients. I know that sounds kind of silly, but I have an example. You know, instead of sending an individual, making it a condition in their order, they need to go see a counselor. You know, why not make it a condition that they see an elder instead in their community? An elder is a counselor. You know, for emotional and spiritual guidance or whatever. You know, it doesn't have to be that specific. And that's something that we're really trying to show and bring to light is that, you know, these Indigenous based programs and culturally relevant programs and services, they're not the conventional ones, but they're still just as important, if not better in some cases, depending on the individual. And yeah, so support does not always need to come from an accredited agency or a professional. And this is where it's important to consider Indigenous ways of knowing, being, and doing. And it is important to consider that our Indigenous clients may find more success within their own communities with support from their own people, and why do we not support that and encourage that? Next slide, please. So here's my lovely list, not my lovely list, the lovely list of Gladue factors that I told you I was going to share. But again, we've heard Gladue factor, Gladue factor, Gladue factor. We've heard a couple of examples of Gladue factors. I really wanted to read this out for the room and for everybody online because these are the factors. Not all of them, but these are the factors that we have to consider and focus on addressing when crafting these plans. They include intergenerational impacts of colonialism and displacement, loss of autonomy via legislation and other attacks on self-determination, racism and systemic discrimination against Indigenous peoples, legacy of sex discrimination in legislation and related policies, physical, sexual, and institutional abuse, displacement of traditional kinship roles, loss of parenting skills, prevalence of violence and neglect, substance misuse, addiction, mental health concerns, lack of opportunity and isolation of communities, high rates of unemployment and poverty, low levels of educational attainment, loneliness, abandonment, dislocation from culture, community, and family, forced attendance at Indian residential school, and the so-called 60s scoop of Indigenous children being removed from their families and adopted into white Canadian families, which is an ongoing phenomenon, as we know. The overrepresentation of Indigenous peoples in the child welfare and criminal justice system. Fetal alcohol spectrum disorder and other related elements. This is, again, a non-exhaustive list, but this is just an example. I could, probably go on and on and on. Yeah, we don't have time. So, next slide, please. So I just wanted to talk also a little bit about barriers and partnerships. So in collaborating to create these plans, there are a number of barriers that our clients are unfortunately experiencing, not only in community, but in corrections as well. Barriers, guys. They're there, and what are we doing to reduce them? So specifically for our clients in custody too, I wanted to touch on this. I'm seeing an influx of our remanded clients unable to access certain services, specifically in healthcare like drug and alcohol counseling. Clients are being referred to dependent on the center, and I'm not gonna put anybody on blast. But certain services in healthcare, like the drug and alcohol counseling. So clients are being referred to seek these supports from an external source, like through a phone service. Does that cost money? Do we know if they're provided a 1-800 number? We don't know. But the fact that they're not able to access DNA counseling while they're incarcerated blows my mind. And I'll tell you why. Not why it blows my mind, but why they're not able to access it. Or being directed, to just wait until they're sentenced or released. So these are our remanded clients that we're talking about. I'm also seeing a lack of support and help with treatment applications. This is just an experience of mine due to a doctor's time constraints, not allowing them to help fill out the medical portions of the forms and suggesting that clients self-refer to recovery houses and then apply to treatment from there. I have a big problem with this. We're adding an extra step. It takes all of 5 minutes to fill out a medical form. Not that I'm a doctor, I'm not a lawyer, I'm just me. But it's these barriers, even in custody, it just blows my mind. And then again, adding that extra step of, okay, wait till you get out, go to a recovery house. How many Indigenous-based recovery houses do you guys know of? 6?
FNHA has a list.
Of Indigenous recovery houses, not treatment. Okay, so this is what I'm saying. So while our Indigenous people are in custody and they're not getting support and help to fill out treatment applications to go to an Indigenous specific treatment center, they're being told, wait till you get out, go to a recovery house, and then apply for your treatment. Sorry. Does that make sense? No, it does not make sense. And so in that example, actually, I was able to find a really lovely doctor from a client's home community who filled out that medical portion. Again, it took all of 5 minutes, and we're able to get this person's treatment application sent off, and they're going to be able to go directly from custody to treatment. Sorry, I lost my train of thought. So another barrier that we are experiencing, a little bit of a lack of Indigenous programming, lack of connection, difficulty even connecting with our clients in custody and having to book well in advance, or slots simply not being available because certain centers restrict professional meetings to specific days and times, which are already often booked for clients meeting with their counsel. A trick, book it as a personal visit. On one thing that we must take into consideration as well is that many of our clients have been remanded for quite some time, and when sentencing comes around, as we all know, our clients might be looking at time served. When our clients are in custody who have been sentenced and are serving that sentence, they are prioritized for access to these services. Why? Why? You know, when somebody who could be, you know, getting their next court date in 2 months, their time served, and then what happens? They're just let out. Are they being supported? Are they, you know, do they have a release planning team like sentenced individuals do? No, they don't. But are they going to be getting out probably at the exact same time as somebody else who is sentenced is? Absolutely. But the difference is someone has served a sentence and someone has technically served a sentence on their time served. But it's just these barriers that we're seeing in regards to supports. That's what we also try to do as support workers, is to just reduce these barriers for our remanded clients by arranging for our clients to participate and engage with these programs and services before, during, and directly upon release for a seamless transition. So just a pump-up story. I was actually able to secure a counselor from Northern Health for one of our clients in custody to do counseling through MS Teams. You know, it's kind of sad that this client is not able to access this kind of counseling, but we just connected him through MS Teams, and you know, but it's something that we have to consider and just really think about why are these the steps that we have to take to do this and to get this done and to have these services available for our clients. And there are a lot of barriers in community as well. We see a lack of transportation, lack of access to modes of communication, like cell phones or the internet, long wait times. We have to get creative in identifying what these barriers are going to look like, and make a plan to address and try to reduce all of these barriers ahead of time so that our clients can find success in doing this. Oh yes. We are also starting to see judges implement Gladue and these healing plans in sentence orders, which I think is really awesome. Again, going back to that piece of Indigenous-based services and resources and programs, we're starting to see judges order those specific programs that we have suggested and collaborated with our clients to facilitate connecting them with those programs. So yeah, whether it be Gladue facilitating the programming, so us continuing our ongoing aftercare supports, we have been named in plans to do that as well. And again, yeah, they're being featured into sentence or probation orders, whether it be the judge adopts the actual healing plan as what becomes the conditions, which has been awesome, or just orders the completion of certain programming that we have identified. Example, I've had a judge implementing cultural resources in community, serving the same purpose of conventional programming that we normally would see on an order. So our role as the Gladue support workers is to create those wraparound supports for our clients by incorporating and utilizing other programs and services, resources, agencies, and identifying how we can best serve our clients. And some clients do need a more hands-on, one-on-one supports, and due to the restrictive nature of remote work, this is where our community partnerships come into play. So none of this would be possible without community partnerships. It is so important to note that collaboration and partnership is a huge piece to the success of our clients' healing and restorative justice plans. We couldn't do it alone. When we are crafting these plans, that's exactly what we're trying to do, is craft a community of support around them, wraparound supports, connecting clients to their communities and their other agencies, like our Indigenous justice partners, support workers in community, and their own nations. It's just so imperative to the success and longevity of our clients' healing journey, is these connections and these partnerships. So it really, truly does take a village. So thank you. Next slide, please.
Oh, this is me. Sorry. So report completion and report review. So once a report or Gladue letter is completed, the Gladue report writer will submit the best copy of the Gladue Report or letter for report review. So that is reviewed by a lawyer outside of the, like a BCF and JC, external legal reviewer, or we now have an internal reviewer, and the report reviewer will suggest any changes needed, formatting, spelling, grammar, consistency, and any issues with legal accuracy. So the report reviewer works with the Gladue report writer to ensure that the Gladue factors contained within the report are tied to the person's current circumstances in an easy to read and understandable manner. So that's kind of how we complete our Gladue reports. That's kind of what they go through before they're submitted to the courts. And next one.
That's me. Hi again. Okay, so I would now like to provide a case study that actually touches on all of the things we just talked about and ties it all together really nicely in a nice example that showcases what we can do for a person. So in this case study, the impact of colonial interference, restorative justice, and community-led options for addressing recidivism is kind of what I would like to just encompass. So this case study is something that I just did. It was my file, and it showcases the success that a Gladue report and a healing plan can have on the outcome, sentencing outcome, and overall life and healing journey of our persons served. I'm using an example, like I just said, from a previous file of mine with a person who I'll refer to as Mr. KL. So Mr. KL came to us with an extensive criminal history, and I'm talking like a lot, like pages and pages, robberies, assaults, like so many, like a lot, and so many that someone might look at this and be like, oh, it's a lost cause. I didn't look at that like that. I didn't. So he had previously spent many years in jail, many years in and out of jail, many years in addiction, homeless, unhoused, I should say. You know, it was not a good situation at all. Now, Mr. KL's childhood was marked with many common Gladue factors, most notably his extended time as a permanent ward of the court since he was 8 years old, and a distinct disconnection from his maternal family, an Indigenous family from a First Nation in BC. Mr. KL identified early on to me that the most important part of his journey to healing and to reduce his chance of recidivism would be to have a reconnection to his Indigenous culture. Now, he also described that his ongoing involvement with the criminal justice system and his history of addiction issues were caused by his feelings of disconnection from his maternal family and the impact of colonial interference. As we sometimes do, as part of our report writing and healing plan process, I reached out to my GSD team to ask if there was any knowledge surrounding Mr. KL's nation and community-led options for his healing plan. A fellow Gladue writer, shout out to Sam Anglem, he's the real MVP in this story, he saw that I was asking about this, and he said, hey, I actually know of an Indigenous family who does ceremonial land-based healing in that territory. And so I thought, awesome. So we connected Mr. KL, gave him the phone number of this family. We said, call him. It's up to you. Call the elder who runs these ceremonies and see what it's all about. See if you want to do it. So Mr. KL actually called them, and they talked. And once he spoke to the family, he actually found out that the elder who ran these ceremonies was taught everything he knew about ceremony by Mr. KL's own maternal grandfather, who he had been disconnected from since he was 8 in foster care. He never saw them again. And he is now deceased. So this connection that was made through our collaborative teamwork and the report writing and healing plan process means that Mr. KL will have an opportunity to learn about and heal from the traditional ceremonial teachings from his own family, his grandfather, that he did not get a chance to receive growing up due to colonial interference in the foster care system. Next slide, please. So Mr. KL's sentencing date came along. He actually went and saw the family before he went to sentencing, which was an awesome step. He traveled there and he saw them, met them. And so I attended his sentencing. And his lawyer, she said I could say her name, Miss McFeeters, she had this to say about Mr. KL's experience. It's actually the second paragraph on the slide. It should have been first, but that's okay. She said, Mr. KL has had a wonderful experience with Ms. Thomas, and he has a sincere appreciation of what he has been connected to throughout this process. In the Gladue Report, it said that Mr. KL was going to meet with a family who offers ceremony and traditional ways of healing in his home territory, but that did happen, and he did go to meet them. He was so detached and so removed from his heritage. He lost his connection, but he regained it again through the process with Ms. Thomas. This is one of two big changes for Mr. KL, the reconnection after so much disconnection. You can see the real effects of what that is doing in his life, for his life, and his children's life. And the sentencing judge in this case actually said, it appears that after the systemic factors that have happened over the last 100 years with our Indigenous people, that we are now at a crutch of breaking the cycle for Mr. KL's children. Here is a major opportunity to break the cycle, not only for the children, but for their dad. The PSR hinted at this, but Ms. Thomas has identified this squarely in the report, which is something I don't see often in the Gladue reports. In the end, Mr. KL was given a 12-month conditional sentence order, with the first 6 months abiding by a curfew of 5 p.m. to 8 p.m. to allow him to continue walking his daughter to and from school, as was a very important part of their routine. And it was a wonderful result. Of course, there's other terms that come with CSOs, but it was a wonderful result because the Crown was actually asking for him to be incarcerated for another at least 4 to 6 months and a year or more of probation. And the judge gave no probation. He gave a year CSO with a curfew for the first 6 months, and after that, you're done. He said, you know, it was important that he was able to do this and be there for his children. The judge began and ended his reasons for judgment that day by thanking me, the Gladue support worker team, and everyone else who wrote or was involved in writing reports for the good work we did on this file, and it's actually published on CanLII. Now, my reason for sharing this with you all today is to showcase the success that a well-done Gladue report and healing plan can have, not only on sentencing outcomes, but on a person's life. And that's what we're dealing with here. It's not just court and someone's court date, their sentencing date. It's their life, it's their future, and it's their children's future in a lot of cases. And the most important takeaway from me with this experience is that it's never too late to give it your all in the Gladue process, whether a person is before the courts for the first or the 10th time. Now, palamiaye pe, that's thank you in my language, all my relations.
Hi, hi. Thank you. And we have some time for questions. I have a few in the chat, but if anybody in the room wants to make their way to the microphones as well, they're more than welcome. The first question that I have is for the panel. How lengthy is a relationship with a report writer, a support worker, and the client? I think it varies, right?
Yeah, I was going to say, I can speak for the support worker role. We know there's a beginning. The middle is quite long. The end is we're still trying to figure that out. It really depends on, you know, like I talked about earlier, the collaboration piece and the partnerships. You know, if we have clients who really don't have any supports out there, I'm going to stick with them until I feel and they feel comfortable that they, you know, can hold their own. But it's really important to build these wraparound supports for our clients, but we don't really have in the support work role, we don't really have a timeline. There isn't really a timeline. And that wasn't really an answer to the question, but
it was a good lawyer answer. I think Courtney's got a question.
Yep.
Yes, thank you all for presenting. It's been very valuable for me as a lawyer to hear that process, and so I thank you for that. My question is, because I have ordered reports, I've read reports, I've had them from formally from the BC First Nations Justice Council, as well as some more informal reports by Gladue writers sort of prior to that takeover. I guess what my question is, hearing about how the healing plans are developed, hearing about how specific and unique they are and how much effort goes into finding very specific programs, as opposed to just, here's a program that might be a good option or a little bit less connected directly with the client. I know for me, I was unaware of just how specific and unique those recommendations are, as opposed to more, here is a range of options that could be good, which isn't a bad thing, but isn't what you've described. And so I think if I'm unaware of that, have you worked with judges or presented this presentation to judges or obviously lawyers today, but to explain just how specific those recommendations are and how you've arrived there? I think for me to be making my submissions, to be able to explain the detail that went into some of these recommendations will make a substantial difference. And so I thank you for bringing that to my attention.
Thank you. I think I can answer that one. A big part of wanting to put on this two-day Gladue in practice was to demystify the process. As you've all heard today, there's the barriers that we go through in the process of reaching the client, beginning the process, interviewing for the purpose of the report, but also all the detail that you need for in-community resources, within working with the nation and that sort of thing. It takes time. It takes time, and there's been a couple of comments and questions also in the chats here asking about the burden and the burnout on the writers and the support workers. Having every file back to back require that kind of attention, and we always require that kind of attention because we know it's important work that we do. And because of that, it is a process that we wanted to share. And yes, we're sharing it today with everybody here, everyone that wants to get their last kick at the can before the end of the year for their CPD. And also we are going to be speaking with the judges hopefully in November. But it's part of the process. We want it to be shared with everyone. We want defense counsel to be armed with that better information about how it works and why it works that way. And we also want the judges to be more aware, because in the last few months, I became very aware that there was a gap in education and knowledge amongst everybody and all of our justice partners, and we wanted to close that. We wanted to bring that education to as many people as we could. And I think we're probably close enough to go to lunch. So we can save the last couple of these questions and we can answer them after. Yeah.
Okay, well, please help me thank our panel once again.
Thank you. We're going to dive right into our next session here. It's a little bit broken up in two parts because we have one of our guests that's sitting here in person and the other is going to be joining us virtually. So first we're going to be spoken to by Kara Hunt, who has done a lot of work with us and also is a well-known criminal defense lawyer with her own practice in the Cowichan Valley. She's also been an external legal reviewer with BCF and JC since I started here. Actually, she's the one that got me in working here in the first place a couple of years ago. So she's going to be speaking on her topic to do with Gladue reports and their successes. And she's also going to be commenting on the video that we're going to be sharing of a testimonial we have of someone who received a Gladue report and the impacts on their life as well. And after she speaks, we're going to be joined by Christina King, who's Crown Counsel with Prince George Crown Counsel Office. And she's going to be joining us virtually. And she graduated from the University of Toronto Faculty of Law in 2019. And she's been called to the bar in both Ontario and BC. We don't see her yet on the screen, but we will. So first, what I'm going to do is just introduce a testimonial video, and then after that's completed, we'll begin our presentations. So the video that's going to be queued up right now is from one person served that we have named Sean Johnny, and he was provided a Gladue report, and in his testimonial, he's going to go over the process and how the process assisted him. So oftentimes we'll just get a report submitted into court, and we don't necessarily know how it goes after that. Especially on our end, we don't always have the opportunity to attend at court for sentencings. We try. A lot of our writers and support workers have made it a part of their own practice to try and attend wherever they can. And so this is one of those instances where we were able to speak with them afterwards and receive a in-person, first-person testimonial about his experience, and we think it's really important to share. So if we could have that video queued up and started, please. Thank you.
I'm not proud of the moment, but I'm just grateful he's still here with us. A steel pipe was used. Geez, within 5-6 minutes, it all went down. We kind of just looked at him, left him there, and we ran away. That's where it all started. It was 1994 for me. And to think back about it, I was struggling with a lot of emotions at the time. Abandonment, untrustworthy feelings towards anyone that was in my life. You know, I kept blaming everyone else in my life, but not really taking a look at who I was. And that's what helped me with this Gladue Report, was to just finally talk about it. Finally let it go. Please just help me overcome this part and not, it was always just deal with the court system, you know, do the pre-sentence report and then do the report, and then either I was on probation or I was off to jail again. And that's what I was so excited for, was having people in my corner that will stand up and speak for me and help me along the process of trying to refine myself. And to this day, I'm thankful for all of them. And I would recommend the Gladue Report to all the nations. The artistic part of me, it's always been here with me. My grandma was a knitter. My grandfather was a mask maker for our ceremonial mask. But over the last few years here, I've enjoyed my new addiction of the arts and creating for my community.
Are you going to do another run of t-shirts?
You know, I'm not a materialistic man, and I'm not out there to make millions of dollars off our art. I just love to do it for the love of our art and our ways of our people. We all can change. We just have to take the time to start believing in ourselves. We hear that word, hopelessness, but it now turned to hope for all of us as a people, no matter where we come from. And that's what has done for me today. Since this report has been done for me, my life has changed drastically. I've overcome all my addictions, I've overcome the court system, and being able to speak for myself and my nation and my people, that's the bigger reward. The main focus down the future is to be one of the best artists of Cowichan. That's my main mission. One day.
just a moment to open my notes. I asked to speak after Sean's video because I know Sean. And I want you to think back to the last moments of that video. Did you see how proud he was standing? He is a proud Cowichan man now. I've known him for quite some time. He looked downtrodden. We've heard people talk about people feeling disenfranchised and they think the system's unfair. It is. And they don't feel like they're going to get a fair shake. That was Sean. I don't recall if I knew him when this Gladue report was done, but I've seen him in the community. I've seen him around court. He actually created artwork and donated it to the Native Court Workers Counseling Association, and it's now displayed at various times in public, giving him the credit and him as a success story from First Nations court. I have art of his displayed in my office and some more on commission. It's just an honor to know him, and if you want to ask anything about him, I could put you in contact with him. He's enthusiastic. He shares who he is and what he's been through with everyone he meets. He'll often come around to court and speak to other Indigenous people who are going through court and share how good this experience has been for him. So when I talk about how a Gladue report succeeds, the goal, to have a Sean Johnny at the end of it. I'm going to be using a lot of my experience as a legal reviewer of Gladue reports, but also I present as defense counsel. I'm a primarily criminal defense lawyer. I present all the time my own Gladue submissions. I wish Judge Wolf was here so I could remind him that he said I should teach people how to submit Gladue factors. It was an honor always to appear in front of him. But anyway, how does a Gladue report succeed? If we're trying to decide how something succeeds, we have to know what our goals are. Do you do the slide or do I? Sorry. I'm not sure who was going to do the slides here. And actually, I have to say first, the most challenging part about making this presentation was doing PowerPoint. Raise your hand if you know how to make a PowerPoint presentation. Okay. Everyone, a lot of people have gray hair. You know, I don't see any of the younger crowd doing this, but I had to wake up a part of my brain that I don't think I've used in 20 years. So it's not the content that was difficult for me because this is something I'm very passionate about. It was the technology. So bear with me. Hopefully these slides will be helpful. So what are the goals? To me, the first goal, which is obvious, we hear it all the time, is reducing over-incarceration of Indigenous people in our system. Oh no, what's happening there? That doesn't look right. Sorry, this could be my fault. Healing, I can read that. I don't know if anyone else can. Healing is the next goal. So the immediate goal, reducing over-incarceration, I would say we could extrapolate that to say we want to keep or reunite a client with their family, their supports, their culture, and their community, and expand their supports, expand their circle of supports. But the ultimate goal, and I hope you'll agree with me by the end of this presentation, is to help a person see their story and connect it to their present as a step toward healing. And I will tell you, I think the Gladue report is uniquely positioned to help a client launch or expand their healing journey. Let's see, the next slide may be the same. I'm sorry. Someone should have done quality control for me. So a successful Gladue report is client-focused, cognizant of use and audience. So the factors that we hear about, and I thank Jackie, did you recall that great list she had for us of all the Gladue factors? She said there are more, but that was the most exhaustive list I've seen in any presentation. A successful Gladue report will always take those factors and bring them back to the client and their own context in their community. There should also be less focus on other people and their words. Sometimes when I'm doing reviews, I'll see a Gladue report that will have lots of quotes from family members or family members' perspective about the client. And where that is useful, you always want to remember, and other people have said this, it's the client's voice that matters most. Sometimes they're still finding their voice and they can't tell us, and we do have to rely on family. But it's always important to take the family's words and bring them back to the client. I have seen reports where the family's story sort of eclipses the client's. And whereas they're all connected, sometimes it's really just this one person's words and their thoughts on things and not really as much about the client. I think it's safe to say that judges generally understand colonialism. I would hope there's no one on a bench in British Columbia or anywhere that doesn't. But you might remember Judge Wolf indicating that one day recently, might have been this week, he had 80 Indigenous people on his list. Do you recall? If someone has 80 Indigenous people on their list, they have other people on their list too, in criminal court, they may only have a few moments to read the report. So it's so important to make sure that it's all tied together well enough, every factor goes back to the client, so that the judge at the end, when they've read this report or skimmed through it, if that's all they have time to do, they know exactly how colonization and the impacts have caused the trauma in this person's life, which has led to this offending that they're having to sentence them on. And an example of tying things back, you might see something in a report that says this person has a history of unemployment or low educational attainment. Why? Why are they unemployed? Is it because they don't have skills? Is it because of no education? Is it substance use? Is it because, and I can't remember if it was Condesa that said children are taken away from their homes to be schooled somewhere else? Maybe that's why they aren't employed or don't have education. They didn't want to leave and be shipped off to a school because they live in a remote community. A successful Gladue report is concise and it's professional and readable. You've got to focus on quality over quantity. I see so many reports that are too long, have too many quotes or whatever going on. And if you took out all the fluff, it might just be a small little bit about the client. And that's not what we're here for if we're centering their voice and if we're putting forward their story. And again, going back to a judge maybe only having a few minutes to read the report, it's definitely better to focus on the quality, not the quantity. No one's getting extra points if you're a writer for writing a longer report. And I've said it, I alluded to it, less use of blocked quotes. Well-known facts that we all know, that colonization has affected Indigenous people. Do we have to say that in a report? I don't think so. You're sort of preaching to the choir. Huge quotes from the Truth and Reconciliation report. Just say something that's relevant to the client and put in a reference where they can go and find that in that really long report. The Bowman literature. I see people smiling if you are a writer and you're here, which maybe we don't have anymore, still here. But the Bowman report is quoted often, the same block quote in every report. I did speak to a couple of judges sort of on a reconnaissance mission before this presentation to get their thoughts, and one judge did say that to him, having those block quotes kind of takes away from it and he just glosses over it anyway. So it's not that you can't quote things and it's not that that can't be useful, but if it's not tied back to the client, it's not going to help anyone. And again, going to copying, pasting, sometimes it's become common, and I think it's important to include history of the person's band, but don't just take something from the website. Don't just take a huge quote from the band's website. Call up a band office. I think Condesa says she does that too. I do that. Call up a band office. Find out how what you're saying about that band is relevant to this person. Going back to the dislocation for schools issue, this person's in a remote community. They couldn't attend high school because they couldn't leave their grandmother that they care for. If that's part of that band's history, incorporate that together. Judge Wolf also, he really needs to be here so he can hear me quoting him. He also said that slow things down. He talked about starting a sentence and then he might tell counsel, let's put this to a different day so we can really focus on this person. I would suggest that from the beginning of Gladue, we're often there's timelines. The defense counsel is on you about, you've got to get this in. I need this. Sentencing's happening next week. And people are so focused on product, the end product, that they don't take time to slow down, and we need to slow down. We're dealing with people who are traumatized, and we're asking them about the most personal and scary details of their lives, whether we're the writer or the counsel presenting it to court. Slow it down. Have as many meetings with the person as you need. Gladue reporting is not just a form we fill out and input details, but that's what it feels like sometimes. That's more like, that's colonialist. To have a bullet point form and you sit down and just try to peg people in. Every story is unique, so let's not do that. And I think those are things I already said. There we go. So a successful Gladue report is trauma sensitive and responsive. I don't really have too much to say about this because there was, that was addressed by the writers themselves. But I will say lawyers, writers, everyone should be building trust before. If you've just met your client, don't ask them if they want a Gladue report and explain that to them. You should be spending time getting to know your client, knowing how to talk to them. I learned from elders in the Cowichan Valley that their traditions of Coast Salish people is to be friendly and agreeable. If I ask someone, and I'm part of the institution, whether I like it or not, I am the them. If I ask an Indigenous client, you know, do you want this? And I haven't built, they don't trust me, I haven't built that trust with them, they're probably just going to nod and say yes. No fault of their own. It's because of colonization. We have to remember that we can actually continue to colonize in this process, and we don't want to do that, obviously. I, myself, ask clients if they want a family member or a support person to attend with them, often just having that second set of ears, someone that they can talk to later. Man, was that lawyer a jerk? You know, or did you understand what she was talking about? And then the grandmother might message me later and say, you know, my grandson really didn't understand what you were saying. Can we meet again? And so I'll do that. So I think that's really important. And same for writers who are writing reports. Ask if someone can come along. And that's being trauma sensitive, but I use the word responsive because that is responding to the trauma-informed approach. Trauma-informed approach isn't to just think, okay, this is traumatic for someone. No, it's to respond in like manner to the traumatized person, to not re-traumatize them or further traumatize them about what you're doing. Again, it should be accessible language. These reports have to be professional because they are going to be filed with court. They're liable to be used by institutions for a long time. They could be used by corrections. They can be used by support workers. They can be pulled up again, as we've heard in some presentations, when someone is sentenced again or going for bail. Historical reports will be used. So it should be professional, but also it can be accessible. You need to try and use language that your client can understand. If a report comes to you and it's not an accessible language, sit down, if you're defense counsel, with your client and help them understand the report. If you are going before the court and you have a Gladue report for your client, you should, at the very minimum, make sure they've read the report, make sure they understand it, give them time to ask questions, maybe even lead them with some questions. And this has been addressed a lot, but I will say it again, I think repetition is good for this. Avoid excessive detail. We've heard of settler voyeurism and trauma porn. I believe, I'm looking at you a lot, Condiza. Those are two words, two phrases that I hadn't heard exactly, but they're perfect for this. We think that just hashing out all of the worst trauma is going to get a judge to go our way, and that's not correct. And one of the judges I spoke to before this presentation said that. I'm tired of hearing someone say, my dad raped me, or my dad did this, or my uncle did that, and specific details even about the abuse. We don't have to name names. We can say a male family member did this when the person was 10 years old. A successful Gladue report is private, and we've heard about this from other presenters too. It's client-centered, so we have to respect their wishes. Again, going back to the trauma response approach, if a client isn't wanting to share something, it shouldn't be forced. If a client doesn't want to share it in court, it shouldn't be forced. There may be things in the report that they have decided, I don't want that said. They've had time to think about it. They've thought about how it's going to impact their grandfather who's hearing this. We don't want to go there. And I want to highlight again, the writers and this group, which I really appreciate, are starting to put labels. I saw that recently on a report I reviewed that said, do not share in court. It was bolded, underlined, it had a text box around it, and it was yellow. So I don't think you could miss it. But it was because that person didn't want that part shared in court. We also deal with an issue of identifying abusers. So maybe grandfather did do something and no one's questioning it, but that person, if that person can be identified by whatever we say, like grandfather on the paternal side touched me when I was young, it can't say that. We don't know if that person was charged. They have a right to privacy too. Were they charged and convicted? That might be a different story. For sensitivity reasons, you still might not include it, but there are examples of when someone was tried and convicted and your client maybe had to participate in a 4-year-long legal battle about it, where they were called to testify and it dragged out and they couldn't get resolution. That directly affected them. So you can see the difference of why you would want to share that information versus something happened, we don't have to identify that person. And I'll go into this later with a specific slide about it, but a successful Gladue report will have carefully crafted submissions by counsel that respect the privacy. So switching from a successful Gladue report is to a successful Gladue report has. What does it have? It's going to have a realistic client-specific healing plan. And we've heard from the writers, I just want to say, they said they were nervous, but they did such a great job. I hope they're watching later and can hear that. They did a great job in their presentation. But they told you they research thoroughly these healing plans and how they can help the client. So when they're researching, it should be focused on the client's community. If this person's in poverty and they live on a reserve in northern BC, don't talk about a program in downtown Vancouver, right? Pretty self-explanatory, but you would be surprised. Another reason this is important, focusing on very specific, well-researched things in the client's community, is judges these days in the system since COVID are virtual. You're not often dealing with, if you are practicing in a small jurisdiction, you're often not before a judge who knows your community and knows what's available. They don't know those elders, they don't know those legal traditions. So it's important that that is in this report for that person. The options need to be possible and accessible. And I'll give you some examples. I think some of them have been mentioned before. Some treatment centers don't take people who've committed arson, not even just an allegation. Let's say they haven't been found guilty. Many treatment centers do not take people who have sex offenses. I think it was mentioned that Vision Quest may be the only one, and I'll keep my thoughts about Vision Quest to myself. I would say they're not the most culturally appropriate treatment center. They're definitely not Indigenous centered. A lot of treatment centers won't take people from jail. So if you've got this great plan and you're going to send your client to this treatment facility after they're released from custody, lots of places, really good places, and a lot of Indigenous places want to see the client in the community for 30 days before, because there's the concern of get out of jail free card. That's what people will say. And The healing plan should expand the client circle of support. And I love that you have the Gladue Support Worker Program now. They can take their healing plan and work with someone to make their circle of support bigger, regardless of what sentence they receive. And that's what it really is all about. A successful Gladue report has successful counsel submissions. They need to present effectively, giving an overview of relevant details, but connecting always back to the client. I notice that good counsel sometimes seem to freeze when they're presenting. Judge Wolf and others mentioned, I think Jonathan Rudin mentioned, that a lawyer will stand up, yeah, there's a Gladue, and sit down and expect the judge to make their own inferences. And I wonder if this is some sort of settler mentality of avoidance. Maybe we feel that we don't know what we're supposed to say, but in my view, that's part of the work we're doing as settlers. I'm a settler. I'm doing the uncomfortable work to repair harm. It may be uncomfortable for me to share my clients' Gladue factors, but I have to do it. Good counsel will highlight the best healing plan options. So finally, a successful Gladue report leads to the healing journey. As I mentioned at the beginning, the Gladue report is poised to help someone launch into their healing journey or to expand their healing journey if they're already on it. The ultimate goal at a Gladue report is healing. And I think we all, every person involved in Gladue from the beginning to the end, need to remind ourselves of that. We need to keep it in our forefront. I think we need to be asking, how can I reduce the harm and how can I facilitate healing? Beyond the report, we should all be doing our part to support Indigenous friends and neighbors. We should watch the language we use, and we should listen, and we should support Indigenous-led movements and organizations. As Jonathan Rudin said on the first day, Gladue goes well beyond the report. I'm just talking and not using my slides. Sorry, everyone. But it's a nice picture to look at. So a summary, the Gladue report is client-focused. It's concise and professional. It's trauma-sensitive and trauma-responsive. It's private when needed and asked. It's realistic and client-centered, and it's effectively presented by counsel. And it should launch a healing journey. So in conclusion, I hope you've taken something from this presentation, no matter what you do. If you're just a person in society who's interested in this topic, if you're a lawyer, if you're a writer, a judge, I hope there's something that you've taken away, even if you're not involved with the report, that you can do in your life applying the Gladue principles. Because we do all have a role to play in the success of Gladue reports in court and outside of court. That's all. Thank you. So I am open to questions. I love questions and dialogue, but I also, if people don't have questions, if someone just wants to stand up and say what they think would make a successful Gladue report, I would love to hear it.
Maybe should we hold questions till the end?
Sorry.
That's okay.
Apparently we're holding questions till after the other presenter.
Just because we have her queued up somewhere
I'll still
out there.
be here.
Thank you, Kara.
Thank you.
Okay, so Anin, everyone, hello. My name is Christina King, Kamanistik Bakwe Rama Dunjiba, Niki Dodem. I am a member of Rama First Nation in Ontario, and I am Eagle Clan. I am also a Crown Counsel in Prince George in the northern region of British Columbia. I just want to take a moment to thank Christina Cook, Amanda Carling for inviting me to present here. I really appreciate that. I'm very honored to be here and to be invited. I'd also like to thank the BC First Nations Justice Council and the CLEBC team for all their hard work organizing the event and facilitating me being able to drop in on you virtually. So I really appreciate that. So I'll just give a very brief disclaimer here. I am here because of my role as a Crown Counsel, but I just want to make it very clear I do not speak for the BC Prosecution Service. Our policies and our public-facing media releases speak for the BCPS. The opinions expressed in this presentation are my own. I'm just here to share some perspectives that I have based on my experiences as a Crown in the Northern region and some things that I've found to work well in my own practice when it comes to not just Gladue reports, but Gladue information in general, because as we've heard in prior presentations, reports are not the only source of Gladue information, and all sources are important. So I am a Crown in Prince George. I've also been a Crown in Smithers, so exclusively in Northern BC. A large number of our files in Northern BC do involve Indigenous accused, as well as Indigenous complainants and witnesses. So we do have a good amount of experience in the North. So very briefly, and I will not go into this in a ton of depth, but I did just want to touch on, just to orient ourselves as to what framework Crown are working within. I just wanted to orient us to the Indigenous Justice Framework and give a brief little spiel about that. That was announced by the BCPS on April 16th of 2019. And I'll just pop it up on the screen here so you can have a chance to kind of read through it a little bit as I'm speaking here. The framework itself, as you'll see in the second paragraph there that you see up on the screen, it recognizes that the status quo is failing Indigenous people. Colonialism, displacement, and forced assimilation have all contributed to the overrepresentation of Indigenous people in the criminal justice system in Canada. So this is a BCPS framework. Our policies in the BCPS have been changing over time after the implementation of this framework in order to align with this framework and bring our work within it. That is an ongoing process. There have been some wide-ranging policy changes in January 2021, May of 2022, December of 2023, and again, they are ongoing. Some examples of this are changes to our bail policy, our charge assessment policy, our policy on intimate partner violence prosecutions, and our policy on dangerous and long-term offenders. Those are just a few examples of some recent changes that have been aimed at aligning our policies within this framework. So I just wanted to give you an idea of what we're working within as Crown Counsel when we have files involving Indigenous people and when we receive Gladue information. So pre-charge assessment Gladue information. It is very important. I don't know if everybody sitting in on this presentation is in BC, but just in case there's anybody from any other provinces, I'll just indicate you may or may not have known, BC is a Crown charge assessment jurisdiction. Police do not lay charges. Crown decide whether charges should be laid or not. So Crown do have a good amount of discretion when it comes to whether to lay charges, what kinds of charges to lay, and whether matters are going to be going to pre-charge diversion, extrajudicial measures instead of the court process. So Gladue information is really important to me as a Crown to receive at a very early stage. I will say it doesn't tend to happen particularly often. I think the resources to get that information in front of me as a Crown don't always exist, particularly if we're dealing with somebody who is before the court system for the first time, perhaps. But when we do get that information, it can be extremely helpful. And I can give one example that looms quite large in my mind. I remember this one very well. I had a file for charge assessment. It was a youth, a young man. He was Indigenous, and he was being, there were some charges being recommended for some very serious offenses. And the facts of the allegations painted a very particular picture of what was going on with this particular youth. I happened to receive, as part of the file, before I even made a charge assessment decision, some information from this particular youth probation officer. He had been on a release order, And the youth probation officer was able to give me a lot of information about how he had been performing on his release order, and a lot of background, a lot of circumstances about his family, his disconnection to his community, how well he'd been performing on bail, that there were some family dynamics that are textbook Gladue factors that were going on in the background for this young man, that he was very determined to reconnect with his home community, which was in a different province, and eventually to graduate high school. Again, he was facing very serious allegations, but he had hopes and dreams for the future. And I was able to get a good picture of what might have been going on in the background as a result of this pre-charge assessment information that I was given. So I exercised discretion in charge approval and what charges I ended up approving, because certain of the charges would have painted me into a little bit of a corner in terms of what I would be able to do from there. And we ended up coming to what I think is a very good result for this youth that might not otherwise have been achieved if I didn't have that information. And I like to find out, as I like to finish the story, I like to close that circle a little bit when I have files, and I do tend to kind of check up on how people are doing after they are finished and done and sentencing has taken place. And I'm really happy to be able to say that this particular youth has since graduated high school. So he has realized that dream, and that was really lovely to be able to see. So Gladue information doesn't always have to come from a Gladue report, as we know. And at this stage for Crown, it's really helpful to me to get information, whether it's from a probation officer, youth probation officer, defense counsel. Defense counsel, if they know these details about their client at an early stage, reaching out to me and sharing those details is really helpful to me, as well as past Gladue letters or reports that might have existed on previous files. So that's just one example of how important I think that information is to get at an early stage. After we've moved past charge assessment, we might have laid charges and exercised our discretion in that way. Gladue reports and information kind of in the more traditional way that we tend to think about them, i.e. informing Crown sentencing positions and the eventual sentence that an Indigenous individual might receive. Those reports, that information gives me the tools that I need in order to be able to make a fair assessment of what sentencing position is best. So you've heard a lot in previous sessions about what makes a good Gladue report, and including from Kara just now, what makes a successful Gladue report. So those reports give me a great deal of insight into what programming and restorative justice options might be available in a community, because I don't always know. I try to have a good idea of what options are available in my community, but things are changing. I'm not the best placed to know all of those details. So the reports are really helpful. If I put this on the screen because I think it's really important. If I don't know where a person came from, I cannot help figure out in a fair way where they should be going from here, or where it is possible for them to go from here. Sentencing is, of course, a very individual process. There is no one size fits all, and it's always really important to know where the person standing in front of you is coming from, what their individual background factors are. That's one of the fundamental tenets of sentencing, whether you're coming up with a sentencing position or, I suppose, if you are the sentencing judge. So I wanted to give another example of a situation that I have faced as Crown, where I got a Gladue report in the traditional sense. It was a full Gladue report, and it was on a young lady who was not a youth, but she was a young Indigenous woman, and she had already pled guilty on her file. Not the most serious of files, but still there was a guilty plea entered. It had never been assigned to a Crown, which is because it was so early on in the process. She had pled guilty at a very early stage. And this was before any sort of concrete decisions had really been made in terms of sentencing position. So she pled guilty in criminal remand court, and then a Gladue report was ordered for this young lady. And I happened to be dealing with the remand court that was going to be doing the sentencing the next day after I received the report on my desk. And I read through the report, and it was very clear reading through that report that there were actually some really great extrajudicial alternative measures options that would have been a really great fit for this young lady. Her background factors were extremely well detailed. They were compelling, and there was programming that was available in Prince George to assist this young lady, but a guilty plea had already been entered. So I ended up reaching out to defense counsel. We had a chat about it, and at the outcome of that, at the end of the day, was that there was an application to withdraw her guilty plea, so that the file could then be diverted to alternative measures instead of and taken out of the court process essentially. And she did successfully complete that program. The caseworker was kind enough to send me a picture of her engaged in a traditional activity, a cultural activity as part of that program. And that was also really lovely to see. So Gladue reports, no matter where they come in the process, it's never too late. I mean, the work is really important, and the information contained within those reports, no matter where we are in the process, can always help inform what the best outcome might be and what the Crown might be able to offer as a resolution position, or again, taking the file out of court entirely and into alternative measures if that's what's most appropriate. So again, never too late. I've heard that in a previous presentation. I think it might have been Olivia, and that's something that I think is important to understand, that I, as Crown, am always also trying really hard to be mindful of when I get reports in front of me and when I see Indigenous accused in front of me. So another aspect of Gladue reports that I don't think tends to get highlighted very often is that they allow for community involvement. And the community, Indigenous communities, or the community as a whole, I think it's important to remember that crimes impact entire communities, not just individuals. And so Gladue reports, when they have the sections where they're talking about what's available in the community, what might the healing plan be, what are the community's thoughts and wishes, that's extremely helpful from a Crown perspective, because it gives voice to that community. How have they been impacted by this offense? How can the offender address that as part of their healing plan? It can give insight into options for restorative justice as a way of restoring balance and harmony to a community. It allows a sentencing judge to consider the views of an offender's community, up to and including. Sometimes what is expressed in these reports is that the community would like this person removed from the community, and that is important to hear and to understand. And sometimes it's not removal, but it's a healing plan, restorative justice. Here's how I can make my community whole again. All of that is very important from a Crown perspective. It helps us better balance our dual role as ministers of justice, because we, as Crown, I think ensuring good outcomes, or just outcomes, I should say, for accused persons is one part of our role. But giving voice to victims and the community is another part. And so I think sometimes there's a perception that Gladue reports are only for the client, only for the individual who the report is being written about. And that's simply not the case. Victim voices, community voices are also amplified as a result of a Gladue report. So I think I might be approaching the end of my time, so I just wanted to leave everybody with a couple of closing remarks that I hope are helpful. And I've also put a couple of links up on the screen to the Crown Council Policy Manual and our media statements announcing the Indigenous Justice Framework and our policy updates relating to that, in case anybody wanted to take a picture for later, but a Google search also works if anybody is curious. So I just wanted to leave everybody with, I think it's important to always try our best to be proactive and find creative ways to ensure that an accused person's Gladue factors are being taken into account at all stages of the criminal process, all stages. And being creative, I think, for me personally, what I have found to work, it means stepping outside of the four corners of whatever box we're assessing a file within on that day, right? The charge assessment box, the sentencing box, this person has been before the criminal justice system multiple times, and I think I already have an idea of who they are box. I have found it works best to try to step outside that box, no matter what stage of the process I'm in. And any information, whether it's in the form of a Gladue report, pre-charge assessment information, anything helps me do that, helps me to not only have one very small snapshot of the whole picture of who this person is and where they might be able to go. I've also found it really helpful to form good professional relationships, whether it be with youth probation officers, report writers, defense counsel. All of that helps me to have as many sources for this information as possible. And then that way I can take into account as much information as possible when making my decisions. So I'm really fortunate. I don't know what every community's landscape looks like in terms of relationships, but I'm really fortunate. Prince George and the North in general, I think, is a place where it's possible to be very collegial and to form those relationships. Youth probation officers can Skype me anytime. They know my face. They know which name to search on Skype. They are aware of us in our relatively small office compared to some others. So that has been really helpful. But I think that that's something that still can be recreated elsewhere if we just kind of put in the effort. And I really liked what Kara had to say about how it's about how can I reduce the harm and how can I support the healing. And I agree. I try to keep that in mind as well. Again, I think we can kind of fall into a pattern, or I at least can fall into a pattern sometimes where I have a lot of files. I might be seeing some of the same people over and over, and I might kind of develop naturally a certain idea of that person. I would like to make sure that I'm always a person who is open to having that idea shaken up and open to new information. And Gladue reports, Gladue information are such important sources of that information. So I hope that all of that is helpful. I hope that all of that kind of helps situate the Crown role, or the perspective of one junior Crown from the Northern region in this. And yes, I just wanted to say a giant chi miigwech and thank you to everybody for having me here, and thank you for allowing me to sit in on all the other sessions that have been so helpful. So miigwech.
I'm just going to see if we have any questions in the room. Again, go ahead and make your ways to the mic. I have one question both for Kara and for Christina, because we were talking about successes of reports. Have you seen in your practices a difference in your preference of use of a letter versus a report, or the benefits of a letter versus a report, or maybe how submissions are made differently from them in court?
I guess I'll go first. I'm thinking of an answer already. Right now, if you go back to my presentation about the block quotes and the long history, letters are appealing because they never have that.
Yep.
But I think we could reach a happy medium where reports would be more desirable if they're more concise. So that's been my perspective. Gladue letters can be used for bail, and that's good. But otherwise, I guess that's my preference, should be more concise.
Yeah, and I will just also touching on that too. We're having a push for the reports to be closer to 10 to 15 anyways, because I know you've all probably received some that are over 20, and I know that's not ideal, but sometimes people have a lot to say. So we are working on that.
Yes, perfect.
And sorry, I didn't have much to add. I was just going to say I don't have a preference personally. I think that it's all up to what region you're in, what resources there are, and certainly your mileage may vary in terms of what different Crown prefer. So I don't have a preference as long as I'm getting the information.
Thank you. We have a couple of questions in the room. We'll start with Dante on this side.
Hi there, yes. This is not so much a question as just an additional observation since we're talking about how to best use Gladue reports and when to ask for them. There's one more circumstance I just want to flag about when it might be important to think about, and that's if you're thinking about a not criminally responsible defense. Because what happens, and we'll hear from Chair Edwards later, I'm sure, in great detail about that process, but also the timelines for that first hearing are pretty short. It's 45 days in most cases. And that, as we've heard from the other writers, that the 6 to 8 weeks is outside of that. So getting a jump on that even before you get to the NCR conclusion of a case means that we will have something much more useful to put in front of the board. Because unfortunately what happens is we have that first hearing, and if there is no Gladue information that we have available, either we have to put together what little we can, or that person might not be up for review for another year. So yeah, getting that process started as early as possible and transferring that to the BC Review Board after the NCR decision or filing it in court beforehand will all help that. So that's my additional suggestion.
That's a good one. And we have another question on that side.
Hopefully I can articulate this well. I've had a long morning. But I was wondering, since there are so many good writers in the world and strong writers, but there's also, you have the odd time where maybe the writing is not so good on someone's story. Is there a way for the person in the experience to then either address that or challenge that at a later point in time? And I ask this because I'm wondering also, over so many period of years, is there the production potentially of more than one report? And if the narrative becomes then conflicting?
Sure.
And does a disservice to someone at a later point? Is there something that, say, I or someone else could do?
I'll try and answer a few of those. We do updates for reports. So if there's a report been written sort of further in the past and there's new charges and new circumstances and that sort of thing, because it's not just the historical information. We also want to put, underlying issues at the time of the offense and anything more recent in there. So we do provide updates. We also have, and Kara can speak to this too, we have a sort of a double review process on the quality of the reports. And that was a newer measure that we brought in sort of last fall. So it's been in place for a while, and I think Kara could probably, I know I can, from my time doing reviewing as well, we can speak to the change that's come to the style of it. And we will take any concerns anyone has. We're happy to hear those. So if there is any person served that was dissatisfied with the report, or there's a concern with it, or there's an issue with accuracy, to please bring it back to us and it'll be addressed. Sometimes sometimes if there is conflicting information or, someone said something at one point, but they didn't mean it the way that it was put down in the report, we can do an amendment to it. And that's just a factual correction. We can do those.
Right. I was just going to say that kind of goes back to my suggestion that counsel should be going over it with their client, defense counsel. That's a step that I know is missed by a lot of counsel. If you're doing that, that should maybe reduce the likelihood of something like that happening. Although it will happen. It's a good point.
Thank you. The name of the guy is Latash. I am from the Squamish Nation. I just have a comment about the Gladue Report, which a lot of good work has gone into it, and I think it's very useful. But for someone like myself, it would be very challenging, since in my culture, I belong to a secret society. So by definition, I probably couldn't use that. Should I make a mistake and break the law, it wouldn't be helpful for me to talk about it. But one of the things that I see missing in the language of the report is the use of spirituality for people. Culture is a very general term, and it probably is inclusive of spirituality, but it's difficult for us to use that, I think. As I said, it's a secret society, so I can't even talk about it in this forum. But it does involve a moral code, though. And to be, pardon? In our secret society? Hundreds. Well, it's a co-salish thing. So in my community, there are hundreds of members of the society and thousands throughout Coast Salish territory in the Lower Mainland and southern Vancouver Island. And it's something that I grew up with. I probably grew up at the right time. Around 1974, I was finishing high school and ready to go to university, and I started to join in with my relatives and friends that were part of this. We call it Sion, and became part of it. And I actually enjoyed the structure of it. My aunt, who brought me under her wing to teach me about it, was a lady about 5 foot tall, but if she got up, she didn't have a very big voice either, and barely above a whisper, but she would get up and stand ready to speak and just say, "Pay attention," in a very low voice like that, and the whole room went like dead quiet. She had so much moral fortitude that, you know, we had a high level of respect for her, and she was one of my teachers, my mentors, and I'm so grateful to her that she took me under her wing. And probably like a lot of teachers, I was a bit of a brat a lot of the time, but not around her though. I was in fear of her. I didn't, more because I didn't want to disappoint her and the other elders in the room. So, you know, we paid attention when she said, "Be quiet, school is now in session." And that was her way of saying, "Shut up and pay attention," basically. So I don't know how useful that would be in the Gladue Report when you're not allowed to say a lot about it. But I think just understanding that there's a high level of trust and high moral values that are passed down to us to learn, and they have a lot to do with guiding life. They're probably like the 10 Commandments in a lot of ways. They're just a set of moral rules that you should follow. So I don't know how useful any of this would be, but understanding that the Coast Salish people do have this cultural practice. Thank you.
Thank you.
Thank you.
Thank you.
I think that's the end of the questions for today. So thank you both to our presenters. Okay, and our next presenter is Talia Magdar, who is a managing lawyer and criminal law services at Legal Aid BC. She is the person to contact if you want to get an IRCA report. So that's the Impact of Race and Cultural Assessment. She is very responsive to all emails. She's a favorite of ours. We've worked together on a few reports that we've had where we do have some individuals that are also in need of an IRCA report, and we've been able to coordinate on those on a couple of times. And it's an area where there is some overlap, and it's really important for anybody that's learning about Gladue to also know about the IRCA options where they do apply. I think I'm just going to let her start speaking now. Thank you.
Yeah, I just wanted to thank the panel before me. It's always really informative, even though we work with Gladue factors and we read about it and we read our own reports all the time. It's always good to get that refresher. And just think about it in a broader sense. So I really thank you, Kara and Christina, for that. And as well, just to say, IRCA is one of my roles at Legal Aid. Another one is just issuing contracts and dealing with requests from counsel and things like that. So if you are a legal aid defense lawyer and you are looking to do things like pre-charge Gladue submissions and things like that, please reach out to us and request funding to do that, because we do want to encourage clients getting the best intervention at the earliest opportunity. So if you have a client that could benefit from hopefully no charges laid due to Gladue submissions, please let us know, because we are able to fund you to do that. So today I'm talking about IRCA, so we'll switch gears a little bit. So IRCA is, I would say, a parallel, sort of similar report in the way that it's produced and sometimes reviewed by courts. That relates more to different racialized communities, more particularly to Black Canadians who are facing charges for criminal courts. They are newer reports. They've started rolling out in kind of the mid-2010s, and there's very few that have been done so far in BC, but basically most of the ones that have been done have been funded by Legal Aid, and we do have an agreement with the federal government to produce these reports on request when qualifications are met. So I'll tell you a little bit about what an IRCA is, or it's sometimes called an enhanced pre-sentence report. And it is essentially a social context report that aims to assist a sentencing judge in understanding the systemic and background factors that have contributed to a person's criminal offending, particularly for Black individuals. We are trying to expand that and working to expand that to other communities, but for now it is pretty much restricted to those communities. Similarly to the Gladue report, one of the main reasons that the IRCA report exists is because of the systemic racism and over-incarceration of Black individuals in Canada's prison population. Just giving you the criminal code section that it relates to as well. Hopefully you're all very familiar with 718.2 subsection E, where the courts have to consider a person's individual circumstances when imposing a sentence. So the IRCA report, did I say what they stand for yet? No, sorry. Stand for Impact of Race and Culture Assessments. So I should have written that on my slide. I apologize for that. But we do call them IRCA reports, and I've just kind of had that in my head for a while, so I apologize. But yeah, so they are reports that a judge is required to consider these circumstances at sentencing, whether or not a report is prepared, that are unique to that person and describe their individual circumstances and what brings them to the court. I'm going to give you some case law. The sites are going to be at the end of my presentation, and I hopefully will be shared with you guys, so you can go and look at those later. But RVX, that was actually the first case that came out in Canada where an IRCA was prepared. It was prepared by a clinician and social worker named Robert Wright. And he actually has grown the IRCA program since the time of this RVX case. And he trains legal professionals. He's spoken to judges, he's spoken to Legal Aid, and he also trains all of the assessors, at least the ones that are in BC, for how to draft these reports. They're considered expert reports. Essentially, Mr. Wright has had to testify a few times as a result of these reports. And they are a bit more heavily scrutinized, I would say, because they are newer and they don't happen as often. And so the RVX case, that was actually a youth. And interestingly, Robert Wright spoke about this individual. He was a youth, he had a very serious charge, and he was facing an adult sentence. And there were two very specific, very detailed reports that went through this person's background. One of them didn't actually even mention that the person was Black, and didn't go to very much detail about this person's community, where they came from, those personal factors that really led to this person becoming involved in the criminal justice system. And so as a result of the IRCA report in this case, a youth sentence was imposed for this individual. So a huge impact on this person, and
a lot of really important things have come from it as well. So again, it talks about the similarities that do exist between Indigenous Canadians as well as African descent Canadians that are overrepresented in the prisons and jails, and that they have underlying reasons for that overrepresentation that are unfortunately similar to Indigenous communities: poverty, substance abuse, lack of education, lack of employment opportunities, and dysfunctional communities. And they are similar factors that are considered, and they are important when considering a person's moral blameworthiness for the offense that they've committed. Obviously, the impacts of colonialism are a little bit different. Not to say that there are no impacts of colonialism in Black communities, but also that they can be really varied. We'll have IRCA reports for somebody who's descendant many, many generations in Canada, or we could have IRCA reports of an individual who's immigrated from another country where there are different impacts of colonialism. And so the person who's writing the report has to go and do a lot of research. We try to get them to match to their own community. That can be really difficult. But they do have to do some pretty intense research finding out where this person came from, what are the impacts that colonialism has had on this individual person, and other factors as well that exist. So I'll go to my next slide. R.V. Jackson, this is an Ontario case, so IRCA moving westward. And it was also a Superior Court case that discusses the distinctions between Indigenous communities and Black communities, even though, again, we have to consider the individual offender when we're sentencing. They have similar shared legacies in terms of colonialism, effective intergenerational trauma, and racism. But again, the relationships that exist between the state and these individuals and the criminal justice system are actually quite different. And so if you do have an Indigenous client who also identifies with the Black population, it could be just an added factor, an added consideration to have something like an IRCA report or at least IRCA submissions when you're considering for sentencing or any stage in the criminal justice process. And this is going to continue on to the next slide. So just another big giant quote for you to read, but talks about, again, the importance of having the IRCA report, the importance of having this information at sentencing to provide the necessary context for this person. I think you're all in this room are really familiar with the importance of individual characteristics when we're dealing with clients before the criminal court. And then the last case I'll take you to, I promise, is R.V. Anderson. So this is actually a typo. I apologize. The correct site is at the end. It's a Nova Scotia Court of Appeal case. And again, talks about the role of the IRCA in the sentencing process, that we serve to enhance the credibility of the criminal justice system in the eyes of a broad and diverse public by increasing the likelihood of sentences imposed being seen as just and appropriate. Respect for the law and the maintenance of a just, peaceful, and safe society is not achieved by putting disproportionate numbers of Black and Indigenous offenders behind bars, having left unaddressed in the context of sentencing the deeply entrenched historical disadvantage and systemic racism that more than likely had a hand in bringing them before the courts. So I thought that's just a really powerful quote from that case, and essentially gives you the background and the principles why we're here and why these reports are so important, and why submissions from counsel are so important in these cases. They're not there to give credit, they're not there to reduce sentences, but they're there to understand why is this person here, what did they come for, and what is their moral blameworthiness as a result of their history. So I'll go into a bit more of the nuts and bolts for the IRCA reports. So who qualifies for them? At this point, our funding agreement is a bit rigid in that they're only funded when the accused is a member of the Black community or another racialized community. They have to be financially eligible for legal aid. And the way that we're dealing with that now is that they have to be on a legal aid certificate. If we may be able to make different arrangements, especially for clients who are clients of the First Nations Justice Council or IJCs, reach out and talk to me about that if that comes up. But at this point, we do require the person to be on a legal aid certificate. And the Crown is seeking a federal sentence if they're an adult, or a custodial sentence if they're a youth. So those are the kind of the rigid funding criteria. There is a bit of room for discretionary funding. So again, if you have a case that you think would really benefit from this type of report, please reach out to me. My contact details are at the end of this PowerPoint, and we can see if we can get that discretionary funding. So I've just put a point there. Accused persons who are both Indigenous as well as a member of another racialized community might benefit from an IRCA alongside a Gladue report. As well in the cases that we have worked on, we've put the writers in touch with each other, and so if they want to kind of collect information together and not put the person, individual through 2 interview processes, that might be something that that could help as well. And as well, if we're unable to fund an IRCA for somebody, they can be paid for privately. What often we will do is ask for you to send me an email. I'll give you the list of our trained assessors, and then you can reach out to them and arrange private arrangements to do a private report. They're also available for long-term supervision order clients or dangerous offender clients. We've had a couple of reports actually prepared in those circumstances. They're usually a lot more paper heavy, but we do have assessors who have experience with those types of persons, and they would definitely benefit from having an IRCA report. And I will also say technically, a plea doesn't have to be entered. That's not part of our funding criteria. So if you think, that you have a client who's facing a pretty serious sentence on an ISP, initial sentencing position, and would qualify for an IRCA if they entered a plea, and you want to use that information in negotiating with Crown for a different sentence, or even for a different type of plea, that's available. So please, again, reach out and apply for that funding. So I'll tell you a little bit about how IRCA works specifically in our province. We are the ones that are coordinating it at Legal Aid BC, and we currently have 7 assessors who are from the Black community to prepare these reports. We also can outsource to other provinces, so we do have connections with Nova Scotia and Ontario that are the other 2 provinces that are doing a bunch of these reports, and I think we also have a writer in Alberta. So we can kind of pull on those resources when possible, though there's pretty high demand. I think Ontario, there's a 6-month wait to get a writer assigned. So we have capacity actually in BC. We're not getting a ton of requests. We are also keeping it a little bit lower volume because we don't know, we don't have a ton of volume at this point. We were looking to expand our program. But essentially we do have 7 assessors from the Black community. We are looking at growing that as well as expanding it to other communities. One pretty high in demand request is for South Asian communities, which is a very big community in BC. So we're looking to try to grow it to that community as well. We do independent legal reviews for our IRCAs, similar to Gladue Reports. We actually use some of the same people to do our legal reviews. And they also tend to be really, really long. And I think a little bit of that is because they're so new, the report writers really want to get in as much detail as they possibly can and really explain the background and context of the report itself. And so they're doing a lot of quoting the case law and quoting the reason why that they've prepared the report. So hopefully, as they get more popular, more recognizable, maybe they'll get shorter too. And I think Kara is going to help shorten them down a little bit with her legal reviews. So timelines, it takes about 3 months to prepare an IRCA report from the time the assessor gets the disclosure materials. And again, as capacity and demand increases, that could change, but we're finding that they're pretty much prepared on track. And there is a bit of a difference between court-ordered or defense-ordered. So very different than Gladue reports, if maybe not so much anymore, but if a judge orders an IRCA report, that doesn't mean that the person is going to get an IRCA report. The defense counsel will still have to get in touch with legal aid, will still have to submit an application, and the person actually will have to qualify for that IRCA report by the criteria I've already mentioned. So just because a court wants one doesn't mean that that's going to be produced. But the court can order it. The only difference is that we will deliver it directly to the court. If defense requests an IRCA report and it's not court ordered, defense gets the opportunity to get it first and decide how to pass that along. Whether they want to disclose it to Crown and to the court is up to them. So either way, we have to be advised, the person has to be on a legal aid contract, and that's how the report gets prepared. And yes, so if you can't get an IRCA due to many of the reasons why I said it would be unavailable, legal aid would fund counsel additional fees or additional prep to draft IRCA type submissions. We have a ton of resources, case law references for you to look at. As well, the Gladue Report Guide is actually a really helpful tool as well for counsel to look at when they're doing IRCA type submissions as well in their cases. So we can prepare and fund for counsel to do that. I also provided a handout that has some frequently asked questions with a ton of this information that hopefully you'll get in your materials. And yeah, a few statistics. In British Columbia, we have been growing. So we had 4 completed in 2022-23 fiscal year, 9 completed in the last fiscal year, and then 2 currently in progress this year. We have views to growing our assessors to try to get training. Unfortunately, at this point, we don't have any funding for ongoing training, but we're looking to try to change that. And as well, we've had a few reports where they've been ordered or been requested or inquiries made and then they've not been completed. That could be due to timelines, but it could also be due to the client not realizing what they had signed up for. I think Kara mentioned that in her presentation a little bit too, is that they are very intensive reports. They go through a lot of background detail. They require the client to go through an interview process and possibly could lead to re-traumatization. And so a lot of clients, not a lot of, but there are a number of clients who've started the process and then not decided to continue. So really important when you are sending your client for an IRCA report, if that's what you're doing, that you make sure that they know what it's going to entail. And again, reach out to me or Kara or someone else that you know who's done an IRCA report to understand the process a little bit better so you can really inform your client before they go in for that interview. And how to get an IRCA. So IRCAs can be requested if you are familiar with legal aid through our portal. You would just request it as a disbursement authorization. And there's also a form that you can obtain from our website through the portal as well. If you can ask me if you need one, it'll just have some basic background information. We'll ask you a little bit about the client, what are their charges, what community are they from, to try to match them up with a writer. And then after that, the coordinator, which is now me, will find an assessor and connect the client with that assessor, who will then need a lot of information to go and write the report, requiring interviews with your client, other people that are important in their lives, and then they spend time writing the report. It gets legally reviewed before it gets sent out to counsel. The big difference with these ones is that legal aid pays the IRCA writer directly, and for the legal review directly, so lawyers don't have to, as I know before when legal aid did the Gladue reports, the lawyers would pay for the Gladue report and then get reimbursed. But right now, legal aid is paying the IRCA report writer directly. And, the components of an IRCA. I did not, hang on. Sorry. So similar to Gladue reports, IRCAs have kind of a standard set of sections where they'll go through and kind of talk a little bit about each background factor, as well as just talk about the IRCA report in general. So the IRCA reports that are now prepared will have probably a page or two talking about what this report is and why it's being prepared. They'll talk about the assessor themselves. They're usually a social worker or a mental health clinician or something of that sort who are trained to write these reports. they'll go through the history of the accused person, including their family background, education, all the kind of different things that you would normally see in Gladue reports. And then they'll talk a little bit about the specific community where this person came from and how systemic discrimination might have impacted them. That's like the meat and potatoes part of the report is how are we linking what happened to this accused person, what happened to their community, how are we linking that to their moral blameworthiness. And then it'll also have recommendations, so it's not called a healing plan or healing program, but it is recommendations for different things that the person might be able to access to help them in their rehabilitation. So similar to Gladue reports, they are looking forward, they are making recommendations to try to repair the harm that was done to this individual as well as to the community. And so then I have just some case law here. These are the, I'd say, leading cases for the rest of Canada. RVX, that's that first case that came out of 2014 of Nova Scotia, and then just some other important cases that have come out of different provinces. And then I have, these are the only reported cases we have in BC so far for IRCA. So if you're looking to find out more about how to incorporate these types of things into your submissions, these are some places that you can go. I'll say I think it's the Anderson and Morris have a lot of really good statistics, especially on over-incarceration. And I've actually used quotes from those cases when I've done parole submissions for clients who are seeking parole. That's one thing, that's one project I have, is I want to identify a client who could use IRCA report in their parole hearing. So if you know of anybody, please reach out and let me know, because we're looking to fund something like that, because I think the parole board needs to consider these factors. They consider Gladue, I would say, not extremely well. They need to do that better, but they should consider these factors as well at parole hearings. And so this is my information. To get in touch with me if you have any more questions about IRCA. And if you have any questions right now, I'm happy to answer them.
Thank you, Talia, for your presentation. I wanted to go back to your comment about how Legal Aid is funding lawyers to make IRCA-type submissions, and this is something that will be, I think, new to a lot of lawyers. I think you said there have been under 20 in BC so far, so the number of lawyers that have dealt with one is somewhat limited. And I wondered what resources are out there beyond just the case law, perhaps, in making IRCA submissions, because before I was with the BC First Nations Justice Council, I'd cite a few paragraphs from Jackson or something like this, but I was wondering if Legal Aid has created any documents for that, or if there's a plan to do something like that. I was thinking specifically about maybe questions for asking collaterals and things like that. I'm wondering if there's a plan for that, or if there's anything that's in place other than just referring to the case law.
Yeah, I think that's a really good question. There's definitely a plan to improve the IRCA reports. Right now, it's something that I'm doing off the very side of my desk, but we are planning to grow it, train new assessors, incorporate training in our province and not just from Nova Scotia. So I think that's definitely coming. I will also just plug, we did an info session on IRCA reports in conjunction with the Sentencing and Parole Project in Ontario back in September of last year, which I believe is on the Courthouse Library's webinars that you can watch. So we dealt with Emily Lamb from the Sentencing and Parole Project, as well as she brought an IRCA assessor with her from Ontario to go through a little bit more nitty-gritty what reports are and how to make effective submissions. So that's one webinar you can watch if you're interested. But yeah, we're definitely hoping to do more in the future.
Thank you.
Yeah. All right. Right on time for your break.
Yeah, actually, perfect. Thank you. All right.
Now we're going to get ready for our next topic, and we're welcoming Brenda Edwards. She's the chair of the BC Review Board, and she's going to be speaking about how Gladue reports are used in the BC Review Board. I know we all heard that she asked a question earlier about sort of how they're used and where they're useful and the difficulty of sometimes using them in those scenarios. And she was previously an alternate chairperson of the board. She's graduated from the University of Ottawa in 1989 and called to the Bar of BC since 1990. She's practiced as legal counsel in the Ministry of the Attorney General, as it was then called, from 1990 to 1997, providing solicitor's advice and acting as counsel on behalf of the province at all levels of court, including appearing as legal counsel in the Supreme Court of Canada in Dalgoma Aboriginal Land Title case. In 1997, she was appointed as an assistant deputy minister and legal counsel in the office of the premier, where she provided legal advice to the premier and to the cabinet. In 1999, she was appointed as assistant deputy minister of the Crown Corporation Secretariat in the Minister of Finance. And most recently, she's begun as her three-term term as chair of the BC Review Board. And we're very happy to have her. So if you could join me in welcoming her.
Thank you. Good afternoon, everyone. Most people have no idea what the review board is, or what we do, who we are. And so I thought I'd take you through a little bit of high-level background just to give you some context, because I didn't get to name the board, but if I did, it wouldn't have been this, because it tells you absolutely nothing. Review what, who, why, right? That's great. So who are we and what do we do? Who we are is an administrative tribunal. But we are appointed under the Criminal Code, Part 20.1 of the Criminal Code, and there is a review board in every province and every territory in the country. So they are populated, if you like, provincially. So our members are appointed by an order in Council of Cabinet on the recommendation of the Attorney General. But after that, the province steps away, apart from sending us a paycheck, and the federal government takes over. So we're a unique sort of hybrid organization. The purpose of the board is to make decisions and arrive at orders regarding the liberty of people who have been found not criminally responsible on account of mental disorder, what used to be called not guilty by reason of insanity, or unfit to stand trial. The board is compromised, or hopefully not compromised, is comprised of at least 5 people. In the case of the BC Review Board, we have 30 members. If you're in a province such as PEI and have far fewer individuals under your jurisdiction, it probably is literally 5 people. But a number of our members are mandated. The chair of the board, in this case myself, must be either a judge or a person who has been qualified to be a judge, so sort of a long way of saying a senior lawyer. Unfortunately, you can tell by my CV and by the graying hair that I am a senior lawyer. And I have alternate chairs. That means on those cases where I'm not presiding, another chair will preside, and they too must be of the same qualifications. The Criminal Code also says that at least one member of the board must be a psychiatrist, and our preference is to have forensic psychiatrists. Again, every panel of the board that hears cases must have a psychiatrist on it. So we have approximately 10 psychiatrists, and right now I think we have 11. We have 10 chairs or alternate chairs, and we have about 10 third-party members. The code doesn't say who those third persons should be, but they must have relevant experience. So we've tried to come up with an array of individuals who might be appropriate depending on the kind of case that they're hearing. So we have psychologists, we have social workers, we have criminologists, we have nurses, we have retired police officers, a whole variety of different people, and it's my job in part to try to make sure that the right people are sitting on the right case. When we convene, in other words, when we have a panel to have a hearing, we typically sit in panels of 3. I see some counsel here who do appear in front of the review board from time to time. You'll know that typically that's a panel with a chair, a psychiatrist, and a third-party member. We are moving to starting to have panels of 5 in some instances, and that is for several reasons. Our cases are getting much more complex. They're more complex factually, they're more complex legally, there's all sorts of different arguments being made, and very often we find that we would benefit from having more expertise on the panel. We also don't sit just one hearing a day. We sit at least 2 hearings a day, 5 days a week, pretty much all year round. A little bit about why there is a board at all instead of just a court. And this really is quite dated, but there's an individual called Hadfield. Back in 1800, Mr. Hadfield shot at the king. At trial, the court said that it would not be fair to sentence somebody who was mentally unill to jail. So he was found not guilty by reason of insanity, but they really didn't know what to do with him at that point. So the court said that he could either stay in prison or he could be acquitted because of insanity. The law didn't think that was a terribly good choice, one or the other, so what was then called the Criminal Lunatics Act was passed in 1800. And that provided that an individual could be hospitalized instead of incarcerated in a jail and should receive treatment rather than punishment. But at that point of the time, if you weren't into a hospital in those circumstances, it was strict custody. That's it. You're there, you're locked up, you're not coming out. Eventually, the law caught up to moral standards, and in 1892, the act was proclaimed. Not guilty by reason of insanity, as I said, became strict, but that was called the lieutenant governor's pleasure. In other words, you stayed in that locked facility as long as the lieutenant governor, in other words, the cabinet, thought it was appropriate. So that could be indefinitely. In Canada, we adopted that code, and then it was amended, not until 1969, so, well over 150 years later. When it was amended, the lieutenant governor and council said that they would give authority to receive expert recommendations on whether an individual should be remain in custody. But that's all the board could do at that time, is recommend. Then along came the charter. And in the case called R versus Swain, the Supreme Court of Canada said that that system where you could be incarcerated, for lack of a better term, locked up in a mental institution indefinitely was a breach of accused persons Section 7, that's your right to life, liberty, freedom, and Section 9, the right to be free from cruel and unusual punishment. And the Supreme Court of Canada said, you got to do better. Parliament then passed the provisions that we still have today. 1992, they passed Part 20.1 of the Criminal Code. That section is what gives us our authority. Section 672.38 says, a review board shall be established in every province to make or review dispositions concerning an accused who's been found not criminally responsible by reason of mental disorder or unfit to stand trial. And it stipulated who's to be on the board. Sorry, bear with me, I'm losing my voice lately. I think you heard Mr. Abbey mention, pardon me, that first hearings from the board must occur within 45 days. So that means if you appear in court, your lawyer has pled you not criminally responsible on account of mental disorder, the court says, fine, we're deferring this matter over to the review board. In other words, we're passing it along to the review board now, and you're the review board's responsibility rather than the code's responsibility, or the court, I beg your pardon. But you have 45 days from that date to get in front of the board. So that means sometimes that the accused has to be found because they may have been released on bail. We had a case with a woman in the northern part of British Columbia, was not on extremely serious charges, but she was seriously mentally ill. She was addicted to substances. She was banned from every local shelter. She was an Indigenous woman traveling on the Highway of Tears and had probably as many barriers as you can have for an individual to face. Her charges weren't minor. They were assault causing bodily harm. But the court had released her because she didn't have a long criminal record. I beg your pardon. Does anyone have a tissue? I'm allergic to air conditioning, unfortunately. Anyway, the court released this woman on bail. So she disappeared. She started traveling up and down the highway. The court had deferred her matter to the review board, so the clock's ticking. We have 45 days to hold a hearing. We have no idea where she is. We went to all of the normal places that you might expect to find someone. We tried the Native Friendship Center. We tried the shelters, found out she was banned from shelters. Tried everything, basically, to find this woman. And eventually, we heard police reports. And we being the registry of the review board. So it's not like we have individuals on the ground scurrying around. My staff are trying to locate this woman so that she can be brought in front of the review board for a hearing. This went on for quite some time. Thank you very much. We heard that the woman had been, arrested again. So we got a hold of Crown Counsel and said to Crown Counsel, please, when you take this woman back in front of the board, ask for her to be detained in custody. Because if she's not, we're going to be looking for her again and again. She's very ill, and she was addicted to substances, and she had nowhere to stay, and it was winter. The Crown Counsel was not able to persuade the court that she needed to be held in custody. And bail, the presumption is release. She was released again. We lost her again. The next we heard, she was in hospital after having been hit by a car. We then learned that she had also been pregnant when she was hit by a car. And so she came to us under very tragic circumstances, and all of which is to say that the code doesn't contemplate a lot of the practical realities of some people's lives on the ground. So anyway, once you reach the 45 days, you must have a hearing. But unlike the court, we don't see a person once. We may see a person 3 times that year. We may see that person for 30 years. When you prepare a Gladue report for a court, it's for a point in time, right? Today, for bail, or today, because you're sentencing. What we need is what is the person's circumstances today. But we might need to know that again next year, and the next year, and the next year. So they are very different circumstances that we're looking for reports in. What the court says is we have to have a mandatory review every year. Once you've been found not criminally responsible, you are entitled to have your matter heard every year. In other words, you don't go into what used to be the lunatics hospital and stay there indefinitely. Every year you come back in front of the board and have your matter heard. And that means that the board is going to inquire, because we're now not an adversarial process where you have Crown and defense and somebody is going to win the case or lose the case. We're reviewing whether this individual needs to still be held in a forensic psychiatric hospital or whether they can be managed in the community. So for us, it's not a zero-sum game. It's not a win or lose. It's what does it take for this person to be able to be safely managed in the community? Because under the criminal code, our mandate is paramount consideration is protection of the public. So we're not focused just on the accused. We are focused on protection of the public, which in many instances involves, if it's an Indigenous person, involves other people in the community, may involve other family members, may involve family members on 2 sides of the story. And we're trying to determine when and where and how this person can go back into the community. So that's an annual hearing. We also have hearings that are called restrictions of liberties. So if, for instance, an individual has been found not criminally responsible and we say, you don't need to be in a psychiatric hospital. You're on medication, you're doing well, not using substances anymore, you're not psychotic, you have somewhere to live. There's no reason why you can't be in the community and be managed by a team, a forensic team in this instance. You'll have a doctor, a nurse, case manager, maybe outreach workers. A whole lot of people can be involved in the team. But if you're in the community, you're on what's called a conditional discharge. In other words, you've been discharged from the hospital out into the community on conditions. And the conditions sometimes look like bail conditions, right? They're not going to be to report to a bail supervisor, but they may be that you need to check in with forensic clinic. They may be that you take certain medication. They may be that you don't consume certain substances. It's not necessarily well known in a large part of the community, but marijuana, which may be legal and may be harmless for a lot of people, will instantly destabilize somebody with a certain mental health condition. Right? So there are a lot of conditions that we may put on that person being in the community. If they breach those conditions and their mental state becomes unstable again, perhaps because they've used a substance, perhaps they haven't, but their mental illness is just going through an aggravated stage. If they become a danger to themselves or to others, the team, the forensic team that's overseeing them, will breach them. In other words, they will send notice to our registry that this person is alleged to have done X, Y, and Z, or they may say it's no longer safe for them to be in the community. We're ordering them to return to the forensic psychiatric hospital. As soon as they do that, it triggers the right to a hearing. You can't just be sent to the hospital and forgotten about. So then we'd hold a restriction of liberties hearing. And we would say, was it justified that this person was sent back to hospital or not? And is it justified that they stay there? Are they now stable on their medication? They don't need to be back in the hospital. So that's another type of hearing. Another hearing that we can have is one where the director seeks an early hearing. And that may be for something as simple as the individual wants to travel to another province, perhaps to attend a funeral, perhaps to attend a celebration. Our jurisdiction is provincial. So there is difficulty as soon as someone wants to travel out of the jurisdiction, but we do it on occasion. And we do it by ensuring that the person is going to have enough medication with them while they're gone, that they're not going to become ill. I had a patient in Victoria who traveled to Mexico during the pandemic, early during the pandemic, planned on being gone for a week, didn't have anybody's particular permission to be there, had no idea that the world was going to shut down overnight. Couldn't get back to Canada, couldn't get their medications. Without their medications, they become unstable very quickly and became a serious risk to the public. So it's that kind of thing. We don't contemplate in advance necessarily, but that's the kind of thing that would trigger a request for a hearing. So all that's just to say, unlike a court, we don't see you once and you're gone. We may see you many, many times. The threshold for you staying under the board's jurisdiction is that you're a significant risk to the public. These are just the parties that will appear at a hearing. Unlike court where you have Crown and defense, we have Crown counsel, we have defense counsel, we have counsel for the director being the director of the forensic psychiatric services, so they will send legal counsel, and we may designate parties. First Nations community may ask to be designated. A mother may ask to be designated. A variety of different people may ask to be designated. If the board feels that they have something important to contribute, they can be designated as a party. When you're designated as a party, of course, you have all the rights of any other party. You can ask questions, you can call witnesses, etc. People are not always on the same page. We may hear from Crown Counsel, this person needs to stay in hospital. We're asking for their detention for another year. Defense counsel may say, my clients instructed me to seek an absolute discharge. They don't want any conditions at all. They don't think they're a significant threat anymore. We're asking you to stop your jurisdiction, basically. Discharge them absolutely. The board may decide to do neither one. You know, the board may decide that it's going to make a conditional discharge. Because in this instance, our job is to inquire. That's why it's called an inquisitorial process. So we will inquire of the psychiatrist who's treating the person. We'll inquire of the person themselves if they're willing to talk to us. We'll inquire of family members if they're willing to talk to us. But this is the stage where Gladue reports would be extremely helpful. We're looking for information. We're looking for information about, you know, what was the accused like when they were healthy versus now when they're mentally ill. What drove them to become mentally ill? Is it something such as bipolar disorder, a chemical imbalance that perhaps can be righted by medication? Is it because they suffered a traumatic brain injury, you know, and now they're not the same person that they were before? What's the reason? And once you know what's going on behind the scene, then we can look forward to what would it take to have the person be safely back in the community. And for some people, that just isn't going to happen. We do have one individual who has been under the review board's jurisdiction since 1974. He was at trial found to have committed 6 murders. He was found not guilty by reason of insanity at the time, and he has never regained enough safety that he can be back in the community. But that's the exception. We may also have someone that comes in front of us under extremely serious charges, but it was at a particular point in their life and in their mental health and in their dealing with issues that they were not, as the code says, criminally responsible for what they did. But since then, their lives may have changed significantly. It may be something as simple as they've never had any antipsychotic treatment before. They've never been diagnosed before. We have individuals who, once they're on their medication, are absolutely fine. And back out in the community, they're contributing members of society. You probably have some friends or neighbors that you don't know are taking treatment for their mental health. If they're not taking it, you may know. As I said, hearings aren't adversarial, they're inquisitorial, and that means that the board doesn't just sit there and receive information. It's not a matter of just what was presented to us. The board inquires. We ask questions. I'll ask questions. The forensic psychiatrist on my team will ask questions. The criminologist or psychologist on the team will ask questions of every witness. And when we think we have enough information, then we reach a decision. If we decide at the end of a hearing that we don't have enough information, then we may adjourn the case and seek more. And it's not infrequent, especially in recent years, that some of the information that we're lacking is a Gladue report, or is information that would typically come in a Gladue report. I don't really care what it's called. So if we get a Gladue letter, or if we get Gladue considerations, that may be all the information we need to know that the person can be discharged into the community. When we do hearings all over the province. So we may be in Fort Rupert one day, we may be in the Kootenays another day, we may be in the Okanagan another day. And if there is a First Nations community involved and they're willing to have that individual in their midst, sometimes they're not, because sometimes the individuals most likely to be victimized are often family members or other community members. So sometimes the community wants to be represented at the hearing, but wants to be there to say, we're not okay with this individual being there right now. In other instances, it may be, we've come to terms with this and we do welcome this person back. And here's the supports that we could offer them. You probably heard me saying to the Attorney General, it's a source of constant frustration for me that we have a lot of people under our jurisdiction because there's nowhere else for them to go. So we have to keep everyone under our jurisdiction as long as they're a significant threat to the public. In many instances, we know what it would take for that person not to be a threat. They need to have housing. They need to have medication available to them when and where they need it. They may need some supports. They may need some supervision. They may need to be free of substances. But if the first thing they need is housing and that's not available, I can't pass go, right? If I say, I know if I release this person today without any housing, without any supports, without addressing their underlying issues of harm, without addressing their addiction, they're going to hurt someone again, right? So then I can't release that person. If I know that the things that they need in order to be supported are available, then I am going to discharge the person. And it may be at the very first hearing. But if the information isn't available, they may not be discharged until the next hearing, or the next hearing, or one after that. I've obviously jumped ahead here. As long as a person is a significant threat to public safety, they stay with us. They stay under the board's jurisdiction. And the code, the criminal code has said what a significant threat is. And that means a real risk of physical or psychological harm to members of the public. It has to be serious. In other words, it's not a trifling matter. And it has to be more than just annoying. So you don't have to have physically harmed someone. Criminal harassment will certainly do it. We've had a case just recently of an individual who traveled internationally for 20 years, criminally harassing the same woman. That's serious, ongoing psychological harm. The evidence was very, very clear that that person had been extremely traumatized, as had members of their family. That will be enough to bring you under the board's jurisdiction. And as I said, it's not an inquisitorial purpose. That means process. That means there isn't any burden on anyone. You don't have to prove that you are not a harm to anyone. The Crown doesn't have to prove that you are dangerous. Once you've been deferred to us by the court, you have that status, not criminally responsible of whatever it is, murder, arson, sexual assault. And that status stays until the board says it's different. So if the board says you're no longer a significant threat, then you're out of our jurisdiction immediately. The board also has powers, as I said, under the Inquiries Act. So that means that we can compel witnesses to come forward if we need to. We can compel people to bring evidence, to bring doctors to bring their records, etc. The options, if you're found not criminally responsible, is as long as you are a significant threat, you may be kept in custody or you may be subject to conditions. I'm sure a lot of people have heard of a number of cases that have been in the news lately. Mr. Schoenborn's case has been in the news a fair bit lately. An individual who was found to have committed the murder of 3 children, his own children, and has been under the board's jurisdiction for, I think, now 10 or 11 years. He's still in custody at this point in time, and he will stay in custody as long as we determine that he is a threat. But as I mentioned earlier, whereas under the old Lunatics Act, custody meant strict custody. You know, the door's locked, you're not getting out. Custody today may be with community access. So it may be that you are staying at the Forensic Psychiatric Hospital in Coquitlam, but you're granted day leaves in certain circumstances, supervised by certain people. For instance, if we have members of an Indigenous community that have come from northern BC to see their family member, they may be granted privileges to take that person out into the community with them for several hours at a time. Or it may be that that person over time has been granted the privilege to stay overnight somewhere or several nights somewhere. So it's a gradual process of reintegration for some individuals, and for some individuals, as soon as they're well, you don't need to have a gradual integration. It can be more sped up. It's very customized to the individual. The other kind of case that we get are fitness cases. They are very different. We are seeing far more of them now than we used to before. If you are brought in front of the court for a matter and the court says you're unfit to stand trial, in other words, you don't understand what's going on. You don't know who the parties are. You may think your defense counsel is part of an evil empire. You may think the judge is part of a conspiracy against you. You can't go through a trial process at that point. You're not fit to stand trial, or you're not able to communicate with your defense counsel. Then your matter will be deferred to the review board. But the minute you regain fitness, in other words, if you're on medication and you're stabilized, and you can say, I know what the judge does, I know what the Crown does, yes, this is my lawyer, I'm perfectly capable of talking to them, and I will go back to court and answer my charges. Then you leave the review board. And if you become unfit again in future, you may come back again. We have some individuals who have bounced back and forth, unfortunately, because they may be fit to stand trial on the day that we see them, but that's because they're medicated, that's because they're off substances, etc. If they're released on bail, by the time they get back to court, they may be unfit again. And that's just the sad reality of it. In whatever decision we reach, and this is where Gladue reports come in, especially for us, is that the board has to consider, we've been told, we must consider the safety of the public. That's the paramount consideration. But we must also consider the needs of the accused, including their need to reintegrate into the community. And here is where we need information. And the individual who is in front of us may not be able to provide that information. They may not be able well enough. They may be totally disconnected from their community. Or they may have delusional beliefs about their background. We find it extremely helpful in those instances to hear a Gladue report that says, this is their history, this is where they're from, these are who their people are, this is where they would be welcomed back. These are the kind of services we could offer them if they were here. They don't need to be in a hospital. That's all important information for us to have. We rarely get that. And that is a real sad reality for us. Part of it, I know, is timing, because we're on these mandatory dates, 45 days from the time the judge sends you from the court to us. You have to have your first hearing. But as I said, sometimes we have individuals for many, many years. So maybe you couldn't get a Gladue the first time, but a year later you could, or 2 years later you could. Or when they're ready to go back to the community as far as their health is concerned, then we need to know, does the community want to have them back? What can be provided to them? I mean, I have an individual who's on the Sunshine Coast in an extremely remote area, but he's living in the community quite well because he has a very solid network of support, not from the forensic services. They see him once every 3 months or so. His doctor might see him by video, but the family has provided wraparound supports that says, we know when he's well and when he's not well. We're going to make sure that he isn't accessing cannabis because we know that destabilizes him. He's got a family member who's going to come stay with him when his father's out fishing, etc. That kind of information that can satisfy us that the person is safe in the community is the kind of information we need. And without it, we can't release the person. I'm not going to read you long quotes. The case law is quite clear. Once we decide a person is a significant threat and they are staying under the review board's jurisdiction, we have to make a disposition, which is just a nice way of saying an order. It's a decision. And that means we're disposing of the matter that year, is why it's called a disposition. But the law is clear. It has to be the least onerous and the least restrictive of that accused person. So while the public and the media will always say, just keep them locked up, This person has killed 3 children, don't ever let them loose, lock them up. I probably have members of my family, some of whom would hold that view. And if I were the victim's family, I would probably hold that view. But the court says that whatever order I make must be the least restrictive one that will keep the community safe and allow the person, it doesn't say their dignity, but really that's what it's about. Allow them to return to the community in as dignified a fashion as possible. So in other words, I don't load them up with all kinds of conditions because I know they'll be safe if I do, but maybe they aren't all necessary. So it has to be the least onerous and least restrictive disposition. The BC Review Board shares jurisdiction with the Supreme Court, and that means that our decisions are appealable only to the Court of Appeal. So when an individual is found not criminally responsible, the court can decide right then to hold a disposition hearing. They rarely do, and I'm grateful they rarely do, because they don't have the information they need at that time. They don't have a lot of information about the accused's mental state at that point in time. They may know what happened 2 years ago when they were charged with this, but they may know nothing about where the person is at today. They may be in a much better situation today. They may actually be in a worse situation today. So we make decisions, as I said, that are equivalent to the court, and our decisions are reviewable to the Court of Appeal. The Court of Appeal does give us a wide range of deference. That's been set down by the Supreme Court of Canada, and that's because we're considered to be subject matter experts. In other words, we have people, and that's all we do, is deal with forensically ill patients. So we have psychiatrists. The court doesn't have a psychiatrist on the Court of Appeal. The court doesn't have a psychologist or a criminologist or an addiction specialist. So they defer to us because they say, you are the right people to come up with this decision, and I hope they're right. That's it. Thank you.
Thank you so much for all the information. I actually do have a very specific question. I have a file that is due for an annual review board Gladue Report. And I'm curious your take on if I should wait. It's not until 2025, early 2025 it's due. Do you think it's better to wait until it's closer to the review board date in case of circumstances changing before then, or should I just get it done now, it's out of the way kind of deal?
Well, I'm going to give you a typical lawyer answer and say it depends, but it does. Because if the situation is static, in other words, the offense was committed X number of years ago, that isn't going to change. That's in the past, right? The information about their family and their history, their culture is static. That's not going to change. If they've been on the same medication for a long period of time and are stable, that's not changing, then I would say, maybe you can prepare it in advance. If it's prepared too far in advance, it runs the risk of not being current, right? So the court may say, or the board may say, sorry, I'm a former member of the court, sometimes I slip. The board may say, well, that's good, but that was 6 months ago. And we've just heard that they went off their medication 3 weeks ago, right? Or that they had a relapse into substance use, because believe me, substances get into secure psychiatric hospitals just like they get into jails. So if the circumstances have changed so that the report isn't useful anymore, then we'll take out of it what we can that's useful, the background, the cultural information, the connections, what resources might be in the community, but we will be hampered by the fact that we know some of it doesn't apply anymore. That's not to say that it's not still useful. If I had a choice of getting a slightly dated report or none at all, I'd take the dated report any day of the week. But what I would hope then is that defense counsel is able to fill in the gap. This is what's changed since then, or, gee, we have a new resource. I'm always hoping there's going to be a new resource. There's now an addiction center, outside of Nanaimo, or, gee, we have beds available in Prince George now. That would be great. So to the extent it's all staying the same and static, yes, you can prepare it in advance. The more current it is, the more useful it is.
Thank you.
Thank you.
So you just gave her permission to procrastinate?
No, I gave her permission to be current. It's more work to stay current.
Do we have another question over there?
Yes, I'm happy to defer if there's any questions online first, though.
Nope. You can go ahead. Yep.
All right. I have a question coming from defense practice. I run a lot of bail hearings that are very short notice, particularly with new clients that I've recently been retained on or duty counsel clients. And I guess my question to you, as someone who's very familiar with the review board and practice, how do I balance my obligations to my client and their confidentiality, as well as indicating to the court if I have fitness concerns? Specifically, I had a case in which the client was completely delusional. However, within the delusions, they still knew what a judge was. Mm-hmm. They still knew what a lawyer's role was. They understood what the court system was supposed to do. They just didn't believe they were in it. Mm-hmm. And they didn't believe anything around them was legitimate. And so I had spoken with Crown about it, and Crown was going to be the one to raise the fitness concern we had sort of discussed, because my client specifically told me, I don't want to go for a fitness assessment. I'm fine. And that was enough that, for me, I didn't feel I could bring it up to the court. My client had given me a clear instruction, despite every other instruction being disheveled. So how would one balance that confidentiality and instruction when, yes, they can give you the technical instruction, but you know that technical instruction is coming from a place not of true understanding? Mm-hmm. And how would one balance that in future?
Well, I would say that the fitness test is a nuanced test. So it is never helpful to just have, my client knows what a judge does. My client knows what a defense counsel does. What it may be, actually, I will give credit to a couple of the counsel in the room, Mr. Mahir and Mr. Abbey. I have seen take this approach before, and I've seen it be successful before. And that is to use a hypothetical. And if you pose a hypothetical to a client and you describe a situation for them where an individual is walking downtown and perhaps goes into a flower shop, takes a bouquet of flowers and leaves without paying, and then you ask them to describe for you, what might they be charged with? What would be evidence in that situation, and what would happen if they appeared in front of a judge? What does a judge do? And you walk them through those questions. It's your job, I guess, to extract the information that is most beneficial to your client. But sometimes what's most beneficial to your client is that they get the help that they need. That's not to say that fitness only is at a point in time, right? So if that point in time you are of the belief that you can't get proper instructions from your client, or that they don't truly understand not just the process but the jeopardy that they're in, then I don't think you're doing them a service. I had an individual, his case was rather complex, could answer all of the basic questions, no problem, quite eloquent, very capable of speaking on their own behalf, really didn't need defense counsel to speak for them. But when you drill down a little bit further and they were asked a few more questions, they would tell you that they had absolutely no concerns about going to trial whatsoever because they'd already been tried. And, the Prime Minister was there at the time, and the Prime Minister has given them, exoneration, and they don't need to worry about it. And then they will quickly segue off and start talking about something else. And from there, they go further and further and further. So it may be a matter of just simply demonstrating to the court where your client's vulnerabilities are, rather than explicitly saying it. Okay? So most courts, and certainly the board, knows what we're looking for. And it's not just, do I understand the roles of each individual, but do I understand my role in that system? And if I believe that, I am sitting on the right hand of God, and it really doesn't matter if I go through this process, because ultimately I control everything anyway, then that information is going to quickly convey itself. It may not come out in the first couple questions. You might have to go a little further. But you don't have to make explicit submissions, in my view. You just need to draw out the evidence. Okay. Yeah.
Okay, I think that's it for questions. Thank you.
Thank you very much.
I'm here to introduce our two next speakers. So Christina Cook is going to speak first. I have the privilege of working with Christina Cook, who is a First Nations woman, specifically a proud member of the Broken Head Ojibwe Nation, Treaty 1, Manitoba. Christina is a senior policy lawyer with First Nations Justice Council. She was called to the bar in 2010. During her legal practice, she's worked in-house for a large national insurer. She was in private practice in BC and Manitoba, and most recently, she's been our senior policy lawyer. Her past experience is broad, including working in areas of civil litigation, regulatory matters, and policy. She's appeared at all levels of court in Manitoba, as well as the BC Supreme Court and the BC Provincial Court. Her bio says that she's active in the community, and that doesn't start to describe what Christina is and all of the many things that she does. The reason she's not physically here today with us is because she's a bencher of the Law Society. She does a ton of community service, and she volunteers for everything. She created the Aboriginal Lawyers Forum with CBABC. She's a director of the Pacific Association of First Nations Women. She's the past chair of the Canadian Defence Lawyers. We could be here until tomorrow talking about all of Christina's contributions to the community. So we're very grateful to have Christina here. And just so you don't have to hear me speak again until after this panel, not at all, can't promise that, but I also get to introduce Hayley Bruce. Hayley is Kwakwaka'wakw, Tlingit, and a Scottish-Canadian mother, wife, lawyer, mediator, sometimes soccer coach, and 60s scoop survivor. She was called to the bar in BC in 2008. Similar to Christina, her accolades are many. She's done incredible work, and I think probably most everyone in the room knows Haley already and all of the contributions. She's a former board member of the 60s Scoop Healing Foundation and a former member of the, what was then I believe called the Aboriginal Justice Council, now the BC First Nations Justice Council. She's served 2 terms as a part-time member of the Parole Board of Canada. She currently devotes her practice to facilitating workshops on intercultural competency, safety, and Indigenous-informed interviewing processes and best practices for administrative tribunals in Canada. And we're very grateful to have them both on the line. So please give me a round of applause for our last speakers, Christina and Haley.
I'm honored to be here and honored to be presenting with my good friend, Haley Bruce. I'm going to talk about Gladue principles in administrative tribunals to just give you a little bit of the lay of the land and then turn it over to Haley. So I'll just start off by saying that Gladue principles have been applied in some cases in administrative tribunals, but not in all. One of the earliest cases that I found was in a residential tenancy landlord dispute in 2005 called Can-Am Urban Native Nonprofit Homes Windsor, where the Residential Tenancy Board declined to consider Gladue factors. In that matter, a landlord actually applied to terminate the tenancy of an Indigenous person. And the Indigenous person tried to apply and have the Residential Tenancy Board consider Gladue factors and how difficult it was for Indigenous people to find housing, the effects of, homelessness, and they actually, the decision maker declined, rejecting the argument, saying that as the case wasn't a criminal matter, it was easily distinguishable from Gladue, and the tribunal was not going to consider those factors. And so that was sort of a bleak start to administrative tribunals considering Gladue factors. But thankfully, other administrative tribunals have further reflected on whether or not Gladue principles are appropriate for consideration, and the thinking has evolved in more recent times. So in 2015, in a case called College of Massage Therapists versus Nandi, Gladue principles were applied in a professional discipline case. In that matter, a massage therapist was in default of her practice fees and continued to provide services despite the default. And her professional association considered the Gladue factors that she put forward and provided her with an appropriate sanction that was less than what would have normally been provided. Also, in other professional discipline cases, including the BC Teachers Association, they have considered Gladue factors in a case called BC Teachers Regulation and GOTS in 2016. A BC teacher was found to have conduct unbecoming in dealing with her kindergarten class. She was found to have, had some anger issues and problematic, punishments, not physical, just yelling. And her regulator considered her own experience and her family's experience with residential schools, and took into account multiple Gladue factors to find an appropriate consequence for her action, and actually specifically said that the Gladue factors she submitted were a mitigating factor. So in addition to, teachers and massage therapists, Gladue factors have been also considered in the professional discipline of Indigenous lawyers. Unfortunately, not in British Columbia, but in Ontario. So Ontario has the most fulsome case law in terms of their law society considering Gladue factors. And it started with a case called the Law Society of Upper Canada and Robinson from 2013. Subsequent cases were Law Society of Upper Canada and Bastogne, and most recently Law Society of Ontario and McCullough. So, and I know what you're thinking, well, how do Gladue factors, affect or take into account a lawyer's discipline? Great question. And I'll start with the Robson case, as it is the seminal case in this area. And should you be faced with a situation as a practicing lawyer where you're faced with a disciplinary matter, this is really the case to start with, or if you're representing a client as well. So the facts in Robson are important for understanding the decision. Mr. Robson was an Indigenous lawyer, and he was being harassed and stalked by a person. This person had tried to assault him, and Mr. Robson had agreed to a physical fight with this person. And unfortunately, instead of reporting the threats and the harassment to the police, Mr. Robson contacted one of his former clients for assistance, and the former client assaulted the other person. Mr. Robson was charged criminally and also sanctioned under the Law Society. Mr. Robson was sentenced to time served in pretrial custody, and afterwards, the Law Society of Ontario determined what would be the appropriate sanction for him. Now, Mr. Robson tried to advise the Law Society to consider various Gladue factors. Importantly, the historical distrust that Indigenous people have had with the police, and specifically as a defense lawyer, he felt that he was subject to differential treatment based on his Indigenous heritage, as well as his defense work on behalf of Indigenous clients. And so he didn't feel safe contacting the police, and he didn't feel like that was an option for him. Unfortunately, the Law Society of Ontario declined that submission, but upon judicial review, it was found that the Law Society should have taken that into consideration and should have appreciated contextual history of systemic discrimination in terms of a troubling relationship between Indigenous people and the police, and that history played a role in the actions that he took. So that set the foundation for law societies to consider Gladue type factors. The next case is the Law Society of the Law Society of Upper Canada. This was before they changed their name. In 2015 versus Bastogne. And in that case, an Indigenous woman was having issues with keeping up with accounting and keeping her trust accounts in order. And she was assisting with a lot of Indigenous clients. And the Law Society of Ontario, in applying the decision from Robson, took into account what kind of supports that she had or she didn't have in terms of community support as well as operational support. And they found that the underrepresentation of Indigenous people within the law was a factor to be considered in encouraging an appropriate sanction to make sure she didn't leave the law. The most recent case is the Law Society of Ontario versus McCullough in 2022, which also applied Gladue factors. In that case, it was unfortunately another serious issue of misappropriation of $116,000 from her trust account. Not all at once. She, Ms. McCullough, had taken funds from her trust account to use for her other areas of practice, typically paying the funds back into her trust account within days or at most weeks at the time of withdrawal. So all money was eventually accounted for, but it wasn't inappropriate use of her trust account. So under these situations, the Law Society would actually typically suspend her license to practice law or even revoke it. Ms. McCullough put forward some important circumstances about how her Indigenous background really affected her actions. At the time of these trust transactions, she was experiencing specific hardship in terms of adoption of 4 of her nieces, who would have otherwise gone into CFS care if she hadn't stepped up. Significant stress of supporting multiple family members, and also help for supporting some of her Indigenous clients. So the Law Society of Ontario considered that this was a unique situation and that these factors that tied to her Indigenous heritage actually had quite an effect on her, action, and that should be considered in the sentence for her penalty. Her penalty was not to be disbarred, but to continue to practice law with a suspension, which was quite an important sanction so that she can continue to practice law in the future and not leave the profession altogether. I'll quickly just mention 2 other cases. I was not able to find any cases where the British Columbia Law Society Tribunal has considered Gladue factors in a written decision, but I did find 2 sort of adjacent cases. There's a case called Moore and the Law Society of British Columbia from 2018, where an Indigenous lawyer filed a petition for judicial review of a Law Society of British Columbia decision regarding her admission to the practice of the bar. She alleged the Law Society failed to consider Gladue factors at the Credentials Committee stage. In that matter, the court found that the Law Society had considered her Gladue factors, but I bring that up as an important case that if you are dealing with a client who's a lawyer, or if you yourself are a lawyer or articling student, there is precedent for you to put forward Gladue factors at multiple stages, not just the tribunal stage, but even at the credentials and admission stage with the Law Society. Another case I want to mention really quickly is Reed Cooley from 2018 as well. And in this case, an Indigenous lawyer brought an application to the Law Society of British Columbia disciplinary panel to have a specific direction to include an Indigenous elder or lawyer on their disciplinary panel. And this was really important as this gentleman was successful. And so if you are facing if you're an Indigenous lawyer or a client, or if your client is an Indigenous lawyer, there is precedent to ask for an Indigenous person to be a member of the adjudication panel. So I think I've burned all of my 15 minutes, and I'm going to pass it off to my good friend Haley.
Thank you for that, Christina. I mean, clearly we've come some ways since Can-Am and the BCTF, but there's a lot more that needs to be done. So I I'd like to talk a bit about some of the work that I've seen and been involved in with administrative law bodies. Really coming from the perspective of therapeutic justice, where the idea is that the interaction with the law can either hurt or help. And I've been trying to find another way to say something other than Gladue. So like section 718 or social context reports, because just out of respect for the family, for one thing, but also because we're trying to broaden the application of the principles, the underlying principles of that case, and establish a new relationship with First Nations and Indigenous people. So, really trying to gain an overview of that application beyond the criminal justice system in an area of administrative law, understanding that what Professor Lauren Sosin has stated, that we actually interact with administrative law far more than we realize. And for First Nations people, of course, for those of us who are recognized as status and those who are not, we know that we actually interact with administrative law under the Indian Act from birth to death. And, it determines what our status is or not, whether we benefit from the protective factors of community through that identity, housing, all of the same things that really in the criminal justice context the factors that we find lacking when it comes to, many of our people who become involved in the criminal justice system. If you lined up those factors, you would also see that those are considered protective factors when you're assessing risk. So we have to try to broaden our understandings about that. Many administrative tribunals across the country have made commitments to reconciliation, and they're looking for ways to educate their members and their staff to change their processes, to establish a new relationship with First Nations people. So that's been part of the work that I've been doing, particularly here in BC, but I've also had opportunities to work with others across the country. And part of that has been to develop an informed practice. And there again, and I think this has some relevance to the issues we're talking about here. I struggle to just limit our conversation to trauma-informed practice, because really what we're talking about is Indigenous-informed practices. We also have a lot of strengths and positive things to draw on, and bringing that to bear in the name of resolving issues that maybe administrative tribunals and other bodies developing that different approach, right? Accounting for our shared colonial history, because it's not just Indigenous people or First Nations people. This is shared. Canadians share this history of colonialism and how that continues to impact participants today, right? I mean, I think that's a point that I've tried to address in some of the work that I've done, workshops and what have you. There is a growing recognition amongst administrative tribunals. You see it through the BC Human Rights Tribunal, who's done a lot of work, the Workers' Compensation Appeal Tribunal, the Civil Resolutions Tribunal, and others who are recognizing that, they recognize the estrangement of First Nations and Indigenous people from the legal and the justice system, including administrative bodies, and are trying to answer those calls to justice by taking steps to ensure the unique circumstances of the First Nation individual or participant are considered in their decision. And that those same principles that gave rise to Section 718.2E can be expanded, and they can be applied to the interpretation and application, for example, of their own area of law, of their own statutes, harnessing those principles as common law principles that can apply along with things like UNDRIP and DRIPA and the rule of law. I would really suggest people read Joanna, I'm not going to say her name right, Prana's Law, maybe somebody knows how to pronounce that, and Naomi Metallic, who write about realizing Aboriginal administrative law. They have some very interesting articles along with Professor Sosin. There is something also that the Law Society of BC adopted. There was a report of the Indigenous Engagement on Regulatory Matters Task Force that came out in July 2023 that I would also recommend that those who are interested read that. And it's really about how administrative law tribunals, they recognize them as colonial institutions. And I thought that was very brave for the Law Society to do that. And that those institutions rely on policies and processes that are inconsistent with Indigenous legal principles. So recognizing the need then for the Law Society as a administrative law body as well to develop a process that's more in alignment with Indigenous values and laws, and you know, to investigate and address systemic issues. So those are some really important steps, I think, and developments in administrative law that we can kind of turn to. Some, like the BC Human Rights Tribunal and the Workers' Compensation Appeal Tribunal and the Civil Resolution Tribunal, are providing Indigenous participants, First Nations participants, an opportunity to self-identify, and then looking for the ways to be responsive to that individual's particular needs in order to participate fully in the tribunal process. But they're also encouraging their members, you know, to exercise their discretion, to get that story below the line that is important, to really then be able to take the active measures necessary to make the necessary inquiries that into the social context, and understanding the subjective lived reality of First Nations and Indigenous participants in those processes. So, you know, taking it upon themselves to be proactive and leaning on the jurisprudence in the criminal justice system to take judicial notice in their own way, so that then the decision maker can gain a better understanding of the facts and factors and the information that's being presented to them, and then analyze that in a culturally competent way that achieves the goals that we say that we have or want of substantive equality, of fairness and access to justice. For example, you know, one of the areas that I raised in some of the training with WCAT was when, for example, you get a First Nations person whose family history is involved in the residential schools, you're getting information from them, and maybe they haven't gone to the doctor, maybe they haven't gone to the massage therapist, maybe they haven't followed through on treatment or therapy that is recommended. So how do you view that information? How would you identify or analyze that information? Well, if you're taking a First Nations informed or any kind of informed approach, whether it's bias, Indigenous, First Nations, trauma-informed approach, you know, you have to ask yourself, well, what's really operating here? What's causing this person not to seek the treatment that you think that they need? And it could be that that person, for example, has suffered physical and sexual abuse, and they're going to delay getting that treatment. Or maybe they live in a really impoverished community and they don't want to make a complaint or file a compensation claim because it might be risk their job. They might not have a job to come back to when we have such high unemployment rates in our communities. So really trying to take a look at the factors that we talk about and then apply them in ways that are really meaningful, and realizing the potential of what we call Section 718.2E factors, or some call them Gladue factors. I'm calling them social context factors beyond the criminal justice system. So dealing with things like evidence and being as part of that reconciliation journey, right? Gathering that information, taking those active measures to recruit, to hire, to train and retain tribunal members. So it goes also to that end, right? The structure, recognizing the structure. I think I only have 5 more minutes. And then they've also, a lot of the tribunals that are now having navigators to help First Nations participants and Indigenous participants to bring forward that social context information that will aid them in the tribunal process and ultimately the tribunal member in arriving at an informed decision that the tribunal, the member, and even the participant can see as just and fair. So looking at how all of these factors might show up and reflecting on the structure and processes that tribunals have, recognizing that there's bias often that's baked into the system that are not responsive to Indigenous people or First Nations people, and then accounting for that. So we're struggling sometimes with the names of them. Some of them are calling them, bouncing around names like the TRC reports, Truth and Reconciliation reports, and things like that, or social context reports, or impact reports. And then asking what information does a decision maker need? And that begins at the first instance, identifying, for example, that you are dealing with a First Nations participant. And then being responsive to and curious about what their needs might be. So having those opportunities to self-identify and then looking for the ways to be responsive to that individual's particular needs so that they can participate in the tribunal process, but also then to encourage their members to exercise their discretion. Some bodies have discretion to, for example, order, do investigative reports, which maybe a social context report would help that tribunal member. And so then to exercise that authority in ways that really help us to achieve our goals. And answering that call for substantive equality in administrative law, challenging the assumption that the law is neutral, and challenging the myth of equality when we know we don't start at the same place and our experience in the world is fundamentally different. So taking into account that history of the broken relationship that many First Nations or all First Nations have with the Crown, recognizing administrative bodies as creatures of the Crown, thinking about the concept of legal terra nullius, where we don't see ourselves represented in those processes, in those laws, the imposition of Western notions of identity and law being imposed on us, and then thinking about the systemic bias and how we might respond to that. So a lot of administrative tribunals are struggling with that reconciliation, those calls to justice. They're viewing, many of them are viewing reconciliation as a verb, so having to really look at their intake, their processes, their information gathering, the way they interact and engage with First Nations and Indigenous participants, the way we conduct hearings or settlement conferences, for example, looking at social research that in the States, for example, that says oftentimes BIPOC parties settle for far less than non-BIPOC parties. And why is that? So looking then at ourselves and being reflective and curious about that, asking how do we account for this person's unique experience in this tribunal process with these particular issues. How did that impact this person in this case? And becoming informed and using our discretion and powers to do that. And using our sphere of influence ultimately at the end of the day. So those are some of the things that, looking at factors like analyzing things for race or the intersectionality of colonialism, systemic discrimination, and how that might present in that particular case. So I think there's a lot of work being done. Clearly, we've come some ways. We got a lot further to go. Those tribunals and processes still do not reflect Indigenous legal orders or values in many ways, but we've started down this path. And some tribunals are picking up what we're putting down, saying, this is our shared responsibility. It's no longer the burden of just First Nations and Indigenous people. It's also our responsibility and being socially accountable for that. So with that, I thank you all for inviting me to share some of my more recent observations and work.
The
question is, are the cases going to be circulated? Christina, I'm looking to you.
Be happy to.
Yes.
I'll email them to Teresa right now.
Perfect. Yeah. Awesome. Okay, thank you so much, Christina and Haley. We'll have to keep the gifts we had for you, all the chocolate, to ourselves. We'll take care of that tonight. Thank you so much for joining us online, and hopefully we'll see you in person soon.
So that brings us to the end of our program. A couple of housekeeping items. First, I just wanted to note that everyone did receive some evaluations. They're also available in the materials online. So if everybody could take a look at those, work through them, and provide us some feedback. We brought together a lot of brains to put this program on for these 2 days. We really want to make sure we hit topics that mattered, and the feedback that's provided to us is only going to help us do a better job of further educating later. And in particular, we wanted to thank CLEBC and Teresa Schuard, as well as the AV team that's here today, for helping us put this on and have it seamlessly be broadcast. I was told the video quality was fantastic, so that's always good to know. And particularly CLEBC, we were able to work hard together to make it so this program was accessible to as many people that wanted to view it, and to make it free of charge to everybody that attended, which was, I don't think that that's a precedented event. I think it might be unprecedented, so we're very happy about that, and I'd like to have everybody join me in thanking CLEBC for their contribution. And just as a final point, and it is off of what Haley did mention as well, something that we have been talking a lot about. Obviously, we know Gladue. We know the name. We know what it refers to in a broader context. We have been spoken to by the family of Jamie Gladue and friends as well, and we understand that they don't actually appreciate or enjoy that the name has sort of been appropriated and associated with a criminal sentencing report. So that is a topic that's in current discussions with our steering committee, and that's with Andrea Hilland and Judith Sayers, Jonathan Rudin, Benjamin Ralston, David Millward, who's here, and Daryl Shackley as well, to name a few of the people in those conversations. We're working towards coming up with something that is all-encompassing and the same way as being descriptive as how we know Gladue to be, but we do want to work towards moving away from that name, and we think that's an important thing, and it's something we've been asked to do, and it's something we are working on. So that's just a tidbit for everyone to know. Keep that in mind as we move forward, and this will still be Gladue in practice, but it might have a different name in the future. So thank you everybody for attending, and I'll pass on to Amanda.
Thank you, Amandeep. It has been a privilege to work with you always, but this is the first time we've done this, and it's fun. So I'll be quick because we want to welcome our elders back up, but just a few closing words on behalf of the council. To echo the gratitude from Amandeep, really grateful to all of our speakers, but especially I want to shout out our staff writers and our support worker, Jackie, Jennifer, and Olivia, not only for being here and giving such beautiful presentations, but also for doing the incredible and incredibly difficult work that you do. Last year, as we mentioned earlier, we moved from a roster model or a hybrid model to focusing more on having staff writers. And the quality of the reports has gone up drastically, but it's been a tough year for our team, and it's really tough work to do. And I just want to hold up my hands to the writers, to the staff, to the folks who are online and who are busy writing reports and aren't watching the CPD instead. Further to my comments yesterday, and yesterday morning feels like about a million years ago, I just want to thank the Department of Justice again for the Gladue Education for Justice System Professionals grant that allowed us to do this collaboration with CLEBC, as well as to the Justice Council's partner in this work, the Province of British Columbia. ADM Colleen Spear isn't here in person, but I believe she was online at some point. She leads the Indigenous Justice Secretariat, which is a fulfillment of Strategy 9, and they are our partners within the government to lead the implementation of the Justice Strategy. Finally, shout out to the Law Foundation for their flexible, respectful, and unprecedented support of BCFNJC. Just a personal reflection, you know, I walked up to the building yesterday in the beautiful sunshine, and I was thinking about this time last summer I was walking outside and I bumped into a couple who I had never met before, who also went to the wrong building for the 2023 Elders Gathering. And we were all kind of bouncing around, and I said, "Oh, hi, I'm Amanda. It's really nice to meet you." And it was Delia and Latash. And, you know, I can't believe that was just 1 year ago. We've come so far in 1 year in our relationship, but in the work that our organization had done. I said at one point, I said, "Yeah, we've got this space we're looking at in the Sun Tower." And Latash said, "Oh, I used to work there. You know, I was a journalist there back in the day." And, you know, we opened 6 IJCs last year. You saw the video. We stood up our Elders and Knowledge Keepers Council, which we're so excited about. We had a huge provincial justice forum, the second one since COVID in May. And yet we've barely scratched the surface of the work that we have to do. Gladue is one of 25 parts of the strategy. The IJCs are another 25 parts. You know, Elder Latash stood up and he spoke a little bit about the Coast Salish Society that he belongs to and the fact that he can't talk about it. And just in that simple example, he laid before us the huge gap between the colonial law and its expectations and its invasiveness and First Nations law. And getting across that gap, that huge chasm between First Nations laws and the way that the colonial law likes to have things done, that is going to be a lot of work. That's going to be at least a lifetime of work for everyone in this room who wants to do it. It's going to get messy, and it's going to be hard and probably a bit painful. But to continue to do the same thing when we know it's not working, I think our expert in insanity has left the room, but we can agree that it's time for a change. The Justice Strategy is not a static document. It was written before COVID. It was written before we had the benefit of working for 5 years and growing a team to implement it. And it was written before we had the 200 plus people who signed up for this event today identify themselves as accomplices in the work. So we've got a long way to go. The AG today called it the roadmap for change. And while that work is never going to be easy, the team keeps getting stronger. And I think, you know, that's kind of the feeling I'm left with from this 2 days, and the number of people who are here, the conversations in the room, the relationships that are being built. And I just am really grateful to everyone for being here. So thank you again, and I'm going to welcome up Elders Delia and Latash Nahaney to close our event and send us into a much-deserved weekend in a good way.
Wachka Tanoyap, Tanoan Siam and Siaya, Sioya Quachit, Tlachit Nomen on Hot and Squallin. I'm very happy to be with you for this gathering, along with my wife Delia. A lot of heavy discussion and very strong, and we want to leave you with a song that sums up our feelings towards you in a good way. And it's called a Journey Song. There are a few words in it that talk about have a good journey, celebrate yourselves and one another, and celebrate your challenges. There's always many challenges in life, but they are just there to make you stronger and to realize how strong you are. We wish you well, wish you a safe journey home. Hey, 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 oh, yo, oh, yo, oh, yo, oh, yo, yo, hey, 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 oh, yo. Oh, yo, oh, yo, oh, yo, hey, 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 oh, yo,
kaho, ohio, ohio, gapayan, hey, hey, hekia, hekia, hey, hey, hekia, hekia, ohio, ohio, kaho, ohio, ohio, chia, hey, hey, hekia, hekia, hey, hey, hekia, hekia, ohio, 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 hey, hey, hekia, hekia, hey, hey, hekia, hekia, ohio, ohio.